This one. Matter may be adjourned for the day, madam. Consent has been taken from the other side.
36, part third.
And for the petitioner lawsuit,
All right,
there is an interim order that may extend.
interim order shall be extended. Adjourn for the day, list after,
Yeah, well, the only senior is out of station, that's why.
Next week, any.
list after 2 weeks.
Much obliged.
May I
36.
please, your lordship? I beg to mention for listing of a criminal appeal, my lordship. It was last listed on 21/10/2024,
Oh.
my lordship.
When do you want?
On Monday, next Monday. 1 of December. Hello.
May it please your lordship. I am praying for listing of higher criminal for suspension of sentence bail lordship. It was last listed on 1/9/2025.
Okay.
Lordship, I can lay it
Next week?
next week on 4th lordship,
Next.
on 4th.
Yes.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 44, Lordship. This matter already been settled, Lordship. It's an NIA matter, Lordship, settled between the parties. Lordship.
44,
44 of daily list, Lordship.
it is High Court.
Yes, Lordship.
488, criminal revision.
Yes, Lordship.
So
Lordship, I'm for the respondent, it's settled already.
it's settled. So we should close it.
Yes, sir.
Withdrawal,
Withdraw, Lordship.
withdrawal.
Lordship.
44, the learned, your good name, please.
MM Zaman on behalf of S. Samaria.
Submits that in the meantime, the parties have arrived at a mutually amicable settlement, and perhaps the matter may be allowed to be withdrawn. Full stop. The said prayer is supported by learned Mr. Gogoi,
MS.
MS Hussain,
AM Bora.
AMS Hussain, learned counsel, appearing on behalf of AM Bora, learned senior counsel. For the respondent, the prayer is allowed. The criminal revision is disposed of on withdrawal. 44 item. Okay.
Lordship, I have another pair for listing, Lordship, two criminal petition, Lordship, or in
Next-
order.
next
order-
week, next-
Highly obliged, Lordship.
Yeah, please, Your Lordship. I beg to mention item number 8, madam. Can this matter taken after some, the first week of December, madam? We have some difficulties today.
Today. List the matter next week. 6th, on 5th, on 5/12. Right.
My lord, it's a 483 bail application, kindly tomorrow, madam. I am in jail, madam.
Okay.
Obliged.
Lordship, criminal revision may come next week on second one.
May it please, Your Lordship. Lordship, I beg to mention a criminal leave petition. It was last listed on 3/9/2025,
Okay.
and it may be listed on, if possible, on Monday, that is 1 December.
Let it be on Wednesday. Monday, we have fixed many matters. Wednesday.
May it please your lordship.
Yes.
Your lordship, anticipated bail application was fixed today, your lordship. The matter was not listed today. May I pray that the matter be taken up with 2, your lordship?
2, we have another matter fixed actually. So after 2, second half,
Second. It is not listed today.
production list.
Deeply obliged, Lordship. My lord, I beg to mention one criminal revision, my lord. We are appearing for the respondent, my lord, and file the Vokolatnama, my lord. Lordship may allow me to, my lord, move the matter on 1st of December, my lord, next week. My lord.
Okay.
My lord. My lord, another prayer is that, my lord, criminal petition, I have filed a party implementing petition
Mhm.
as per this honorable court's order.
Mhm.
That may also be taken up for party implementing petition on 1st of December.
On the same day.
Obliged.
May I please, Your Lordship? Lordship listing for a withdrawal criminal petition.
Okay.
Lordship, another pair listing for AB, Lordship.
When?
Tomorrow, Lordship.
Not tomorrow, Monday. Monday.
May please, Lordship. Lordship, listing for a 482 petition, may tomorrow, my lord.
Let it be on Monday because we fixed many matters.
File it on 22 mile.
Okay.
Tomorrow.
May I please, Your Lordship, one bail petition last listed on 6/11/2025, Lordship. Next week will be 3rd of December, Lordship.
Okay. Why it's not coming up in the regular course? Otherwise, its mentions won't be necessary.
May it please, your lord. Lordship, item 46, my lord, that 313 matter, my lord. On the last
Okay.
occasion, your lordship
Hmm.
pleased to fix it at 2, but somehow it's not reached, my lord. Today, after the conclusion of the bail matters, my lord, because it will not take much time, my lord.
Mhm.
Only that whether your lordship will examine whether 313 was there or not.
Yes.
After conclusion of bail matters, my lord, if possible.
There's some case law also.
Case was
Okay, we'll try to take it up.
Deep level.
Your lordship, I beg to mention for listing a IA criminal tomorrow, lordship.
Not tomorrow, let it be on Tuesday.
Like,
we have urgency.
No, this,
Okay.
everybody has urgency too.
Alright.
We have to listen on
Anticipatory bill.
We are for looking for one criminal petition letter on Tuesday.
Okay.
May I please your lordship? Lordship, I beg to mention item number 12 of the court number 21 for listing lordship.
Number 12.
Well,
There is a urgency lordship.
this one, when do you want it?
Tomorrow maybe lordship.
Tomorrow, I do not know the subject matter. Anyway, okay. Fixing is not a problem, but you don't reach, their list is too long.
May I please your lordship? Which I beg to mention for listing it. I criminal lordship. On
Next week,
next week. Wednesday lordship.
next week. Which date you want? Thursday.
Third of,
Third,
third.
okay.
May I please your lordship? Your lordship, I beg to mention item number 23.
Of my code, this one?
Yes, lordship. Scan copy was called for, but it
Yes.
has not been received, lordship.
AB, right?
Yes, lordship.
2458. Scan copy. Not received, right? Not received. Scan 23, scan copy is not received. Issue reminder, scan record not received, issue reminder. Are you on interim? Interim bail is there?
No, lordship.
Is the matter next week then? Next, on 5th? Is it okay?
Let's.
Hey, please, your lordship, I beg to mention item number 29. Here CD has got received and service not completed.
Case diary not received.
29.
Case diary not received. Issue reminder, interim?
No,
No interim.
next week,
Next, 4th or 5th?
yes.
Which one would you prefer? 4th or
fifth.
5th?
Now, may I please mention item number 14 of Justice Jahan's matter, my lord,
No.
motion matter, my lord.
Yes.
Well, there is a little urgency in this particular matter. The lower court matter is fixed on Saturday, my lord.
Yes.
It's a recalling of an NBW order, my lord.
Okay.
So I'm against that NBW order. If it could be taken up today, my lord, if it's not inconvenient.
Okay. Can I take up her matter? Huh?
Only mention.
Only mentioning, I think. I will not be able to take up, I think. What is the
Then if
notification?
it could be fixed at 2 o'clock, my lord. Otherwise, tomorrow also, if it's not.
Tomorrow. Can be fixed tomorrow. I don't know whether she'll be available, but I think only mention, I don't think I'll be able to take up, right? I think tomorrow.
My lord.
Tomorrow, we'll take a chance tomorrow.
My lord. Deeply obliged, man.
May I, your lordship, I beg to mention item number 63 from supplementary list, adjournment for some instruction may needed from the time.
It's the three of supplementary list.
On 10th of December.
Just a minute. 63 bail application. Scan record might have been available. It has been received. It's in custody, right? So you, when do you want it?
10th.
10th of December. Okay. If it's not late for you, it's okay. Scan record is available. However, learned counsel seeks an adjournment and prays for fixing it on 10 December. So list the matter on 10/12/2025. 63.
Item number 2.
One is wrongly listed.
May it please your lordship. Here,
Yes.
33 numbers of house were seized, my lord.
Okay.
But my lord, already my lord, by an order dated 26/11/2025,
Mhm.
the ICJM, my lord, Vishwanath has directed the IO to give Jima of the.
Okay. To the accused person, to the owner.
Oh, no. And my item 57 to devotion, is the owner of the my lord, Kettles, my lord. Lordship, kindly see page 23, 28 onwards. Well, these are the valid receipts.
Counsel.
The petitioner in item number 57, he passes.
Just a minute. I'll mix up otherwise. First, let us do this matter.
Man.
First, let us do this matter. For these 4 petitioners, right?
Yes. Number 1, the driver, and others are members of the.
Others are,
Others are helpers. man.
Helpers of the
Helpers of the vehicle.
and item 57 is the owner.
He owner, man.
Owner is also he's
I
anticipating.
anticipate, my lord, pays my lord,
Which one should I take up first? The anticipatory
A-
bit? AB?
anyone. my
No,
lord.
because the facts may be different.
Same facts, my lord. Page 46 in the BA, my lord. Yeah, it is the, my lord, certificate of trading, my lord. He is of cattle, my lord. Cattle trading certificate issued by the veterinary bureau. And Nityananda Kaman, who is the petitioner in 57,
Mhm.
he is the
Okay.
trader, my lord, registered trader, my lord. He purchased the, my lord, cattle, page 28 onwards
Mhm.
from Gugamukh Weekly Market.
Mhm.
These are valid receipts, my lord.
Mhm.
But my lord, when the, my lord, vehicle was intercepted, they could not produce these documents.
Okay, so they were
They were
apprehended.
apprehended, and cattle were sent to the, my lord, Gosala. And subsequently, he moved a, my lord, Zimma petition before the, my lord, SDJM, Vishwanath, my lord. Upon verification, that was allowed to be given Zimma.
The ownership is under investigation.
Yes,
The
ma'am.
ownership is,
Yes.
but,
But he has to produce the documents, my lord, as per
he
the
claims
order.
to be the owner.
Oh,
right?
no.
That's it. Claims to be the owner.
Unless and until my lord, he produces the documents, the ownership cannot be.
True, that is.
That is why, my lord,
Mhm.
bail in place. And other persons, my lord, they are in jail, my lord.
AB 28, first we'll take up the AB.
Otherwise, question is not who is the owner of the kettles, whether to own kettles were handed over to the original owners. But question is how they were transporting those.
Yes.
kettles. Prima facie,
Whether it is violation of cattle
yes,
preservation.
prima facie cruelty.
That will be decided in the trial, my lord.
482 bail application by the petitioner Nityananda Kaman, Bihali PS case 100 of 2025. That's all it's a section. The FIR is dated. Where is the FIR? The AB
FIR, my lord, in the AB.
15/11/2025.
My lord.
Stop.
Is 10.
The allegation in the FIR dated 15/11 is that on 14/11/2025, during a NACA checking, one truck bearing number AS01 TC 5405 coming from Gohpur towards Biswanath Charlie was intercepted and found to be carrying 33 numbers of cattle in an unhygienic and
Cruel manner.
cruel conditions. Full stop. The driver and the occupants of the vehicle were arrested. The present petitioner, next paragraph, the present petitioner claims to be the owner of the said vehicle. The learned counsel has placed before this court a order dated 26/11/2025 passed by the learned JMFC.
And as the same,
Ordered SDCM M. Vishwanath Sarali on the petition of the present, on the petition of the present petitioner seeking Jima of the cattle. He's the owner of the vehicle or the cattle?
vehicle both, my lord.
Both cattle and vehicle. Jima, interim custody of the vehicle as well as the 33 numbers of cattle. The said Jima petition has been disposed of, the direction to verify the ownership and do the needful to give interim custody of the material objects sought for. Full stop. Call for the case diary from the concerned police station. However, in the interim, in the event of arrest of the petitioner, in connection with this case, he may be allowed to go on bail of rupees 25,000 with one surety of the like amount to the satisfaction of the concerned learned court. SDCM M saying it's not sorry, and subject to the conditions that he will cooperate with the investigation, semicolon, appear before the IO for examination. Number 3, not hamper or temper evidence. Another condition, not commit any illegal activities, including any activities prohibited under the Assam Cattle Preservation Act. and Prevention of Cruelty Act, Cruelty to Animals Act. Full stop. List the matter on so and so date. This is also there. BA is also there.
BA malware,
They were
allowed
arre-
malware because their driver and malware they are.
they were arrested on 15th. Then we'll have to give a shorter date because the both of them can come together.
The first week of malware December.
Let us see. Let us.
On my lord, 5th of December.
এইটো বাকি একে ধৰণৰ খালি the four accused petitioners here were arrested on were stated to be the driver and other helpers of the vehicle and were arrested on 14/11/2025. All for the case diary. Which date you suggested? What happened?
5th of December.
5/12.
Highly available.
Item number 3.
57 আছে না?
57.
Item 3. Yes.
Lordship, it's in bail application under 483 DNSS, Foxo matter, your lordship.
So matter.
And the case has been charge sheeted, your lordship, and it is pending for trial before the.
Trial is not started.
Trial has been started.
Start.
Yes, your lordship. The FIR is in stage.
At this stage, when
Clubbed it together and made it commercial quantity. And one of the accused person is also granted bail by coordinate bench, lordship, that page 27 on the ground of non-compliance of section 48. So let them file their affidavit, lordship, in this regard and.
what is the judgment? You know, there is a judgment, no? That has to be, the quantity has to be seen in a segregated manner,
There are
right? From the-
And our coordinate bench.
There are judgments in favor of Department of
Yes.
Justice.
No, I mean,
During single, then it is total quantity is to be.
yes, yes. Suppose jointly is there, and then it can be, suppose this intermediate quantity is recovered from A and commercial quantity from B, ganja say, same article, then it will be clubbed together or it will be separate? It will
If
be
it is a
separate.
private vehicle, then it will be clubbed together.
Yeah.
But if it is a public vehicle, then they have to show what are the materials which connects both of them.
We'll
That is the-
produce the case diary along with our objection.
Yes.
Look up that case law also. you know. Logically, and since a beneficial interpretation is given, you know, when there are two views, then probably it has to be segregated.
Second, their coordinate.
They can
bench
give
order
both
is-
the sections. In fact, they can give both the sections, 20, suppose 20C as well as 20B. They can give like that also in the section against one B, against one C. But that will depend on if the Honorable Supreme Court has spoken on the issue, that's the last word.
Yes.
Our view does not.
Categorically observe that there has
Yes.
been material regarding
We'll see that.
abatement and conspiracy.
Heard so and so, the understanding of NCB. Call for the case diary. It's under investigation, right?
No,
Yes. Call for the case diary of NCB Guwahati crime number 7 of 2025 under section so and so. The accused herein was arrested on. When was he arrested?
arrested on lordship 24/6/2025.
24/6/2025. The prosecution is at liberty to file a reply/objection if any. So, when should we fix it? You can choose a mutually convenient date. 9th? 9/12.
Pablo,
53 CGST.
Yes, Mr. Das.
Petitioner is in custody since 13/11/22. My lord, your lordship may kindly see paragraph 10, page 28. He is a cafe owner where, my lord, some person, Samir, has gone there and has done his
28, right?
page 28.
What happened?
Just for the purpose of showing that he is the owner of this cafe.
Cafe.
And this cafe, Mr. Samir went and he has done his registration.
Okay.
So therefore, my lord, and I'm stating, my lord, paragraph 10. That is the facts. Very high-ended manner, they do it and they, my lord,
And he's, he is, the allegation is about evasion.
yes.
Evasion
yes,
of GST.
Yes. My lord, he is the owner
Paragraph?
of the cafe, paragraph 10,
Okay.
11 and 12, your lordship will kindly see, that is the fact. No supply has been received from him, he has not received a single piece money also. And he has not supplied any materials. On this ground itself, my lord, very high-ended manner, my lord, some about 20-25% went to his cafe, my lord, picked up all his materials, not even a seizure list has also not been given to him. And thereafter, my lord, on the next day, they have shown that he has gone to the office voluntarily on 14. But in fact, it has been done on 13 itself. And on the next day, he has been produced. And in total violation of section 47 and 48 of the GMS. Your lordship will kindly see, I'll just show, my lord, from paragraph 15 of the complaint, paragraph 7, my lord. Yeah, of the complaint petition, start from page 15. Paragraph 7, your lordship will kindly note that there is no supply order. He has not supplied anything, neither he has received any
Yes.
amount.
Yes.
That in his statement, Sri Samir Malik, I am not Samir Malik. This person went to my cafe and he has done his registration. He is the owner of this farm.
Cafe.
Yes. Page 17, my lord, of the complaint petition, paragraph 7. So this Samir Malik, he accepted that he is the owner of all this farm, primarily engaged in the trading of battery scrap. All these farms are there. Then paragraph 9, your lordship will kindly see. That is scrutiny of data derived from so and so portal in respect of so and so indicated issuance of fake invoices without supply of underlying goods leading to wrongful availment and utilization of RTC. So admittedly, Samir is the owner of these two farms. So how this petitioner, who is a cafe owner,
The petitioner is Baharul Islam.
Bahadur Islam.
Bahadur Islam.
Islam. And then and paragraph 10, your lordship will kindly say how this conclusion has been received. Paragraph 10 below just about 6 lines. Therefore, Sri Samir Malik and Sri Bahadur Islam, being the operators and beneficiaries of NA Enterprise and E-Waste. How they say, Malad, I am the owner of the enterprise. Mr. Samir has already accepted.
He is accused of conspiracy or something, working together.
No, Lordship, there is allegation that they indulged in fake issuance of fake forms and taking ITC on fake forms.
But not by the petitioner.
Yeah, Lordship, he was integrated in jail also. And Lordship, allow me some time, I'll produce the entire.
Case diary will be there.
Yes, Lordship. Everything is good.
But can it be taken up? It is from Guwahati. Malad, it is completely fully covered by the judgment of this honorable court.
No, please.
Should I place it? Yes.
The accused Bahadur Islam was arrested on 14/11/2025 in connection with anti-evasion GST, CGST, and within bracket anti-evasion unit Guwahati case number 93/GST/2025-26 under section 132 read with section 69 of the CGST Act. I'll go through this.
There is no ingredients of section 132 that doesn't apply to the petition.
Call for the third vote. PD Das, SC Kyle, with standing counsel. Call for the case there. Let's the matter on. When do you want? Should I fix it?
Let it be on tomorrow, my lord. He's just.
A lot of matters are fixed actually.
Fifth, I will be out of.
Next week, I will be out of Lordship.
Will you be available on Monday?
Monday, Lordship.
Let it be tomorrow at 2 p.m.
Tomorrow. Is the matter tomorrow? 28.
54.
Well, my lord, I am claiming that I am innocent because I was arrested in a misconception of facts, my lord. Kindly have a look, page 5, paragraph 6, my lord. Page 5, paragraph 6 and 7.
Page 5, paragraph 6 and 7. Okay. He had introduced,
Yes, my lord.
he had introduced
Because
the person.
one person said that he has to sell his vehicle.
Hmm.
I have uploaded in my Facebook ID, my lord, that vehicle that I
For sale.
I am a mechanic, my lord,
Oh.
for sale. Then that Rajibuddin, my lord, approached before me, and I have made an connection between
Let us see
the
the FIR. Let us see the FIR.
FIR page 14, my lord.
14.
Yes.
Otherwise, we call for the diary at this, at this,
Because how can
see that at that time.
why short date, my? Because I am an innocent, my lord. I will assist you.
Schedule reveal.
Not that easy.
It used, no, no. Call for the case diary of Bajari Chera PS case number 130 of 2025 under section so and so. The accused was arrested on 22/9/2025. Stop. The learned counsel submits that the petitioner is completely innocent and he was arrested on mistaken facts. This is the matter on, call for the diary.
A short date, maybe.
16.
Maybe more. Before first week of December, my lord, possibly.
GST matter to you. GST matter.
GS 15.
So. GST matter.
15 December.
You want it little
may be,
early?
my lord, even maybe the second week of December, 9, 10, 11, there are lots of it. 9, 10.
10.
10. Obliged.
55.
Look at page 38, my lord. Is the order of the magistrate, my lord.
Yes.
Well, the second paragraph, my lord.
Mhm.
The IO had produced following narcotic drugs, psychotropic substance, controlled substance is sealed, 14.78 grams suspected heroin contained in 10 vials, 1.37 grams without the vial, my lord. Small quantity, my lord. 1.37, my lord.
What is the judgment? It's not a reported judgment. It's the order of a high court, right?
My lord,
This is the order of a high court.
Tripura also there, my lord.
No, this Tripura won't be now under it's a different high court. There's a judgment of the high. What do you say, Mr. Botak? It's because the magistrate has certified it to be a small quantity. So it's in a bracket of small quantity. It's a bailable offense actually. So 27A has been given or what? Which section has been given? Then it will not come then. 27A. Yes. Let us see the FIR.
My lord. The FIR lordship will find at page 9, my lord. Sorry, my lord. 27.
This is name, not the.
One year. 27 to 1 year. Got it. No, 27, 18.
27A has been done. 37 will be applicable. Anyway, call for the case diary then. At this case. Otherwise, if it was only small quantity, probably would have had to consider interim. But now since 27 is there. So
And my lord, one more, my lord, mistake has been done, my lord, in the instant case, my lord. I am again drawing your lordship kind attention to page 38, my lord. 38, my lord, fourth paragraph, my lord. Similarly, the prayer to take photographs of the seized items before me is hereby allowed, and the photographs of the seized substance were taken in my presence, and I hereby certify the said photographs are true. Then, my lord, the seized suspected heroin is contained 10 plastic vials. They are of identical appearance and a homogeneous mixture is made. That homogeneous mixture cannot be made, my lord. Ultimately, my lord, the trial will vitiate, my lord.
Homogeneous mixture.
Homogeneous mixture. Homogeneous mixture can be made of cough syrup or tablet, something like that.
That has to be seen. Homogeneous mixture made of the entire seized article.
Yes, my lord.
Sample 1, 3 grams of suspected heroin. That we have to see anyway.
My lord.
Let us get the diary.
My lord, can it be on 5th of December, sorry, 4th of December.
Doboka, right?
5 তারিখ,
Fourth, don't take it on fourth, fifth.
Fifth.
Fifth or take it on Monday.
Monday.
Take it on 8th,
My lord,
or maybe, if
my
it is okay.
my lord.
Call for the case diary of Doboka Pace, 226 of 25, and so and so. The accused was arrested on 12/11/2025. Full stop. List matter on 8/1/8/12.
Fine.
8.
I'm of that.
56.
Wait, huh? Yes, Foxo is there. Also there, right? So, service
completed.
service is complete. Anybody has appeared?
No, no.
So I'm-
Because the informant son-in-law is involved and then some misunderstanding was there.
Amicus will.
CD also not received.
Huh?
CD also not received.
Not, also not received. Oh,
Several days have gone by.
yeah, please get the CD if he's saying that. He's on interim, but still. The case diary is not received. Issue fresh reminder for the case diary positively on the next day. Interim bail while order dated 15/10/25 stands extended till the next date of listing. None has appeared for the informant despite being noticed accordingly. Manisha M.R. Brown, Manisha Karen Brown, learned counsel appointed as amicus. The petitioner shall furnish a copy to the learned amicus. We'll take it up on after. Get the case diary on the next day,
Yes.
right?
Yes. Because cut with the
22.
Monisha, Monisha.
Okay, amicus has been appointed by the.
Yes, now, just now. You furnish a copy.
May I please, your lordship. As per the interim order dated 15/10/2025, the petitioner appeared before the IO on 22/10/2025
Okay.
and again appeared on 19/11/2025. Statement may be recorded here, Your Honor.
Statement has been.
May- Though there was no specific
Oh,
direction. to
recovery.
appear before the court, I appeared before the court. IO on 22/10, Your Honor.
SC/ST Act.
Yes. The petitioner here is the area receivable manager of a finance company, Your Honor. There is no specific allegation against the petitioner in the FIR, Your Honor.
Just a minute, just elaborate order.
Co-accused has already been enlarged on bail by Your Honorable Court. Height order dated 31/7/2025, Your Honor. I have annexed the
Okay.
earlier order.
Okay. It's a
I am
El-
cooperating.
elaborate order anyway. Huh? CD receipt.
The statement of the petitioner is available. in
And
the-
that you have to see because otherwise,
Otherwise, the allegation is that.
where SC/ST Act is given by virtue of that amendment,
Yes.
18A, anticipatory bail is not available, but I think you are, this judgment, right, Sharia,
Yeah.
Sajjan's Karia, state of Kerala, it says that if there is no prima facie case made out on the regarding SC/ST Act from the materials, then you can give anticipatory bail. Otherwise, it is abolished, right? So which order you have annexed? The final disposal?
Case number 147, Your Honor. Your Lordship,
It was a regular
AB, Your Honor.
AB.
AB, Your Honor. FIR name accused, Your Honor.
Following the due procedure of law,
Mhm.
we have with the help of some.
Kunz, my lord.
Just a minute, I just see this.
147, Your Honor.
Preliminary inquiry report, the IO had said that there was no evidence of any custody slurs. Right. So therefore, this was given at that time. Now, I don't know what the investigation is doing.
Statement of some of the witnesses.
Hmm.
Is that they stated that as per the instruction of the present petitioner, my lord, they went there to recover the.
No, that is another aspect. I mean, I'm primarily looking at this aspect. Otherwise, it will not be maintainable. also.
Maintainability
right?
aspect, yes.
So this was there's a reference to the preliminary report in this final order. It was disposed of, granting them anticipatory bail. But if the same situation prevails now also in the up-to-date CD, then we can consider for them also, perhaps. Kindly see that preliminary report and whether any, whether prima facie case is there under SC/ST Act.
Otherwise, my lord, the informant is, my lord, belongs to, my lord, that SC/ST, my lord.
Yes.
And prima facie, yes, there are, my lord, some of the statement of the witnesses that, my lord, regarding, my lord, applicability of the, my lord, SC/ST Act.
No, there has to be a kind of statement slur, and with regard to a person belonging to the category, and in public view with the intention to insult
Yes.
and derogate his dignity. That is the crux of the offense, as far as I know. There are not many cases of that act in this part of the country. And so we are not that much familiar, luckily. Yeah.
FIR, statement in the FIR itself, one statement is there.
And but the IO in the preliminary inquiry, which was relied upon to give an interim and final order,
Yes.
that he had,
Regarding that aspect, my lord, I have.
kindly see, the preliminary report had returned a finding that he did not find elements of that
Regarding that,
caste slur
regarding that aspect, my lord, I will check your lordship, may kindly take after some
after
time,
some time.
because-
Because in some parts of the country, this is
Petitioner
applied
was-
very,
petitioner
there is a
was-
stringent law.
Petitioner was even not in the present on the spot, you know. FIR.
No, then it will not be applicable. Kindly see that.
FIR does not
Yeah,
speak about
he is
the-
not present also,
Not
then
present, Your Honor.
this part will not come.
At that point of time, petitioner was not present, but
Not
as per the
present.
instruction of the present
SC/ST
petitioner, other accused persons, my lord, forcefully recovered the
So,
vehicle. my lord.
That is
SC/ST
another
Act, no, does not-
Kindly have a look
Yes.
after some time.
24, 25.
Maybe.
Yes.
You know, in 24, I am appearing, and 25, my learned friend is appearing. So in terms of the interim order, petitioners appeared before the IO, and there is that.
Diary has been,
Diary received.
but we had appointed some.
I ordered it. CD not received.
But this is a quite an elaborate order of our High Court.
Lawsuit.
No, it must be, it must be reported, Kisan.
Lawsuit.
So anyway, I'll check it up. Thank you. I'll check it up. So there's no interim, right? What are the sections given? Other sections given? Theft. Theft.
And other.
317 is what? 317.
Dishonestly received or.
Stolen
retained
property.
any Stolen property.
Stolen property.
Minor, small.
May come also. Depends also. When can you get the case diary? Gohpur.
I'm ready to cooperate the IO.
Hurt so and so. The allegation in the FIR dated 7/2/2025 is of the petitioner illegally storing diesel and running a business of selling the same, full stop. It is submitted by the learned counsel that though penal provisions of BNS pertaining to theft and dishonestly receiving stolen property has been given, but if at all, the only section 7 of the Essential Commodities Act 1955 might come, and that the same offense is valid. It is submitted that the petitioner is willing to cooperate with the investigation. The case diary is not yet received. Issue reminder for the same. However, in the given situation, it is directed it in the event of his arrest, so and so, 25,000 at once here, and subject to the condition that he shall cooperate with the investigation, appear before the IO for recording his statement, and not misuse his liberty to commit any illegal activities. I'll keep this.
Yes.
Chairman to command us. List the matter on. You can give a longer date. It will clear some jam.
Yes.
Those in interim cases, you give a longer date.
January, 6/1.
6/1.
6/1.
Okay, no option. Also holidays are there.
31, sorry, 65.
31 of 31? No, no.
It's a very small issue, my lord. Whether poppy seeds will come under the ambit of the.
No.
My lord, I have yesterday, my lord, I have
Yes.
given a judgment.
I remember.
My lord,
Just a
Himachal.
minute, there's some small mix up. 31. Sudarshan.
I
I will take it up later. No problem. Don't worry. Fine. The fine. Yeah, your matter.
My lord, 65.
65.
Otherwise,
My lord, I have yesterday, my lord, I have supplied one, my lord.
It must be in the.
Apex Court judgment, my lord.
Mm.
State of Himachal versus Nirmal Kaur, my lord.
Mhm.
There, my lord, paragraph 26, my lord.
Let us study that. File to the. Poppy seeds.
Some time to go through the thing.
Okay. Poppy seeds. So I'll just have a look at this thing. Judgment is not there. Judgment is not. No, judgment is not here, I think.
Then your lordship, I can take.
No, sorry, you had submitted.
Yes, sir. Anyway, my lord, I have.
It must be, it may be with my law clerk. No, I usually take it out only after completing.
Fine.
Give it
Paragraph 26, my lord.
26.
May I read, my lord? In the present case, we are concerned with the conviction in relation to poppy straw. Poppy straw has been defined to mean all parts of opium poppy after harvesting, whether in their original form or cut, crushed or powdered, and whether or not juice has been extracted therefrom. However, the said definition excludes the seeds.
As such, poppy straw would mean all parts of opium poppy except the seeds.
Except the seeds. So in the instant case, if a lordship turns to
It's a fine distinction, but there must be some reason
yes,
why this distinction is
the
there.
poppy seeds is
Because
one of
we do not know so much detail
the
about.
poppy seeds, what we call the afu guti, my lord.
Mm.
It's available in all grocery shop, my lord.
So that cannot be.
That cannot be.
Prohibited drugs.
Yes, that is my.
So that is why it has been
My-
excluded. Forensic people also know, will notice things anyway. Not.
The quantity of those pilot seats.
You go through,
Yes,
you can
I'll have to-
study.
Because
Uh-huh.
whether,
Bail application. No. No, why I filed. Because they 65. 31. No, 65. 60. I'm giving it back to you, but I'll write it down, this judgment. Nirmal Kaur. State of HP.
Yeah, paragraph 26.
We'll see. You can also see this paragraph written in.
Should I keep it, man?
I'll keep it in the file. I'll return it back to you. Para 26.
take it up tomorrow.
After,
No, the lordship will pass the order. You
no,
do it.
no, you want some time to read it? After some time or tomorrow, we don't know what list will come.
Yes.
If it is possible, we'll take it up in the second half.
I have made my submission, but
Okay.
let him. My friend will be there. Man.
Yes,
I'm all right.
he's good enough. Well, after he's ready, his submission is complete. Video পায়, রয়ে-
31.
রয়ে গেছিল।
May it please your lordship.
Yes,
Lordship, in this matter, TCR was called for and
yes. TCR is called for.
that has not been received and services also awaited. Lordship.
Services await.
31 TCR not yet received. No.
I see. Scan TCR as called for is not yet received. Issue reminder for the scan record of so and so POCSO. What about the service?
Regarding service also.
No, as per the record,
I will
it's
get
not
the-
complete.
I will
The
get
prosecution shall take instructions from the concerned PS regarding service upon the informant. List on
On 10, 12.
okay. Is that okay?
Lordship, carrying period 9.
Yes.
No problem. Ninth. Particular ninth.
God bless you.
66.
Let's see. It's after some.
After some time?
Yes, sir.
Okay.
Much of it.
67.
Yes, no, Lordship. Lordship, as per your direction, I have submitted copy onto the running semi circular.
Yes.
This is hard-seated matter, my lord, but it has been shown as absconder, my lord. In the FIR, the patient name has been shown, my lord. And next date is on 5/12, my lord. I am ready to appear, my lord. And several order has been passed by your,
NBW is pending.
no, my lord. Only someone has been issued, my
Oh,
lord.
someone has been issued.
I am ready to
Oh, I see.
face the trial, my lord. In several order, I already submitted before the lordship. Yes,
Of,
sir.
of co-accused,
No, my lord.
no, other cases.
Other cases.
Other cases.
Coordinate.
Any cases like this, record has come, I believe. I'll come to you. It's not. One 61 statement, can you, because I'm finding it difficult to read, this is the handwriting. 164, I have read. I've read 164. Have you gone through the record?
Yes, madam.
Yes.
I have flag marked.
Flag, I've seen.
Yeah, yesterday. that
Thank
was
you.
done.
Uh-huh. But the allegations are
Yes.
Seriously.
serious.
Section 4.
161,
I face the trial, my lord.
Uh.
In any condition, my lord. I'm ready to face the trial, my lord. And the during the investigation, my lord, police never interrogated me, my lord. No steps have been taken to arrest me, my lord. That is why I don't know about this matter.
Yeah, absconder charge sheet has been
Sir,
given. Absconder.
my lord, found as ex-convict, my lord.
Uh.
And perhaps I have marked the house search list, my lord. Yes.
Victim is also,
Yeah, the house, there is a house search.
yes, yes.
House search made, but
What is her contention in the 161? She's supporting
164.
161. 164 I have read.
Is not here, but I.
161, I have some problem with the handwriting.
It's not there.
You can have a look. Rest I've gone through.
Yeah.
This 376 have been added. Rest of the
161
matters.
and 164, whether it is any different.
You have a look.
but Otherwise.
You just have a look and submit.
Yeah.
Otherwise, investigation is complete, but whether it will be prudent. Yeah.
Lordship, in POCSO matters, child's welfare is paramount. Lordship, your lordship, though his name is not mentioned in the FIR,
Mhm.
but it has been reflected that the informant, she got a call
Mhm.
from an unknown number.
Mhm.
Later, that number, after investigation, it came into light that it was registered in the name of the accused.
This person,
Yes.
this person, unknown person.
But the police never interrogated me, my lord. He never comes in my house.
That is one factor there. He is stated to be, the allegation against him is that he helped to confine the girl in the house. The main allegation is against that person, other person. Now about rape allegation is against. Then he is the main accused. He is the main accused. Sukur Ali. Now this has to be, we have to clear this, just And what about the other accused persons? They are,
Only one person has been shown an absconder, my lord, against me, my lord.
okay, the others?
Others, no, my lord, they are.
Hamidul Islam and Sukur Ali, I think this is same person. Page 16, Lordship.
And in the started it
16 Lordship.
reflected by Khanedul and Sukur Ali, one and
Let us see the charge sheet, yes.
There is no
Page 16.
other witnesses with
Tahidul Islam,
Khanedul.
the Sukur Ali. Sukur Ali,
Only the mobile number, my lord, that is what.
only one person is sent up for trial. Sukur Ali.
FIR is so different, my lord. Some experience.
Yes, yes. That was anyway. My grandmother's kidnapper. Okay.
161 also implicating Sanidul, my lord.
Hmm?
Sanidul alias my lord Sukur.
Alias Sukur Ali.
In the charge sheet, his name is given as Sukur Ali. He is given as son of Madan Ali. Madan Ali. Hmm? Can I have a look at the 164 again? It's not annexed, na? Have you annexed? No.
It is not, but it is here, man.
Hmm?
It is.
Let me check, huh? This. Not suppose. 161 is on similar lines.
Similar. First day, my lord. For total, my lord. They got intimate, my lord, after that.
Sanidul. Sanidul Islam, she has said.
He has said Sanidul.
She has referred to as Sanidul. But charge sheet has been filed against Sukur. That's I think maybe we can then consider. It has to be clarified very properly at the stage of framing charge. What is the, you
Because in the FIR written by the IO, my lord, specifically there is Podokya Sukur Ali alias Sanidul.
Oh.
That is,
he should have mentioned the alias name in the charge sheet.
yes, in the charge sheet he has mentioned.
No, only Sukur Ali.
No, my lord, it's mentioned.
Mhm. Where?
Page
Charge sheet is
Page 23.
23, your lordship.
23 of the
23, page 23, second paragraph. Of the petition.
Oh, I think so. Yes. Sukur Ali alias Sanidul Islam. No, in the column he should have mentioned. He should mention.
Yeah.
And this must be incorporated if charge is framed alias. Otherwise, it can be very problematic from my experience. So what do you say? He is willing to cooperate and appear, but at the same time, examination of the victim, all these considerations are also there. We have to balance both the things.
And he has seen that there are several times visited the house of the accused person.
He's avoiding, of course.
He is there on the.
Anyway, let's see what can be done.
On the
Heard this
our
one.
coordinate bench or lordships have some order for them. It is together in the
Anyway.
figures of absconding circumstance. In the NDBS case also, my lord.
Heard Borua and for the additional PP and Bornita Chaudhary, B. Chaudhary, learned amicus appearing for respondent number 2. Full stop. The petitioner is seeking anticipatory bail invoking 482 BNSS in connection with special POCSO case number 42A of 24.
Abbas Ali, he hired the vehicle
Mm.
on 25/6/2025 and brought the vehicle to Mongoldo area. Lordship.
Okay.
And being a driver, owner of the vehicle,
Mhm.
he accompanied that person while he returned back from Mongoldo in Gadubanda area. The vehicle was stopped by the police personnel.
Naka
of
checking.
Mongoldo. Yes, Naka checking. And after checking the vehicle, they found some 5 numbers of white colored plastic bag full of suspected to be ganja, Lordship. And answer delivered, namely, sir, Lordship, that is page 12, NHO 1, Lordship.
Yes, let's see. Page 12.
Yes.
Mhm.
Here it is specifically mentioned that with due may I
Yes, sure.
with due respect, I have the honor to report you that today I was entrusted to perform Naka checking at Guruvanda Point near Kolaingam along with DSP so and so, OC Mongol PS with my staff so and so at about 8:25 AM. That is on 25, Lordship.
Yes.
AM, a vehicle bearing registration number so and so Tata Magic coming from Kolaingam side towards the Mongoldo side, and OC Mongoldo PS signaled the driver to stop the vehicle. After that, I along with staff so and so have intercepted the vehicle, and during checking found 5 number white color plastic bag full of suspected to be ganja. I asked the driver, namely Hazrat Ali, it is the petitioner, Lordship, and passenger, this is basically
Abbas Ali.
mentioned as Abbas Ali, about suspected to be ganja. Both of them speak ups and down after that OC Mongoldo PS case number so and so, GD number so and so, who was also present at SP, the Deputy SP, Torun Medi, who was also present at that PO, directed the authorized me to take necessary steps to seize the suspected to be ganja and the vehicle. After I called 2 numbers of local witnesses, namely so and so, both were residents so in village Goduvandagi, and briefed them about the incident and asked them to remain present as witness. After that, I informed the person available in the vehicle, namely Hazrat Ali, son of so and so, and Abbas Ali, son of so and so, both are residents of Kochutolis, PS Sunapur, and I am going to charge them to record their consent. It's an oral consent. I also informed them that they can be charged in presence of gazetted officer also. Since the DSP was DSP Darang present before it, so the apprehended person gave consent for search. All are oral consent they have stated about it. After that, I searched both Hazrat Ali and Abbas Ali and found 2 mobile phones belonging to them. I already recovered 5 packets of, I already recovered. Before sir, he has recovered 5 numbers of packets suspected to be ganja inside the vehicle. So I weighed suspected to be ganja packets with help of weight machine of police station in presence of witness and other available staff as well as local public. These suspected to ganja weighted approximately 25.34 kg. With plastic bags. After observing all the formalities of the NDPS Act, I seized 5 packets of suspected to be ganja along with the vehicle bearing registration numbers so and so, and the mobile handset belonging to the apprehended person, and prepared a seizure memo by containing signatures of the apprehended person and witnesses. After that, I along with seized suspected to be ganja, the seized vehicle and mobile phone apprehended person Hazrat Ali and Abbas Ali returned to PS. After arrival, the handover the seized items to the registrar for keeping the seized article PS Malkhana by MR number somewhere. And after that, I submit the FIR upon the apprehended person, namely Hazrat Ali and Abbas Ali and Goduvanda ganja peddler who are doing illegal business of ganja and destroying the new generation. That person has been apprehended in 25/5 at 8 AM, Lordship. Kindly turn to page that is 23. That is the forwarding report, Lordship. This is typed copy of forwarding report. Here the name of Hazrat Ali, Abbas Ali, and
yes, they both were forward.
page 21, and actually
Yes, both were forwarded.
Forwarding report, that is one dated 26/6/2025. He was appearing in the morning 25, but they have been forwarded before the special judge, Mongol Dorong, at the next day, 26/6/2020. It is not related to other provision of the NP Act. It is the Narcotic NDPS Act. Special provision is there to how to dealt with. Next, Lordship, two persons' names are there. Date and time of arrest. They have sent the forwarding report mechanically, showing that 25 to 21
Wrong.
at 8 a.m.
8 p.m.
8 p.m.
That's wrong.
But he was arrested 25/5 2025. This is one of the discrepancies.
25/6.
And ground of arrest kind of turn to page 22/6. Credible information found regarding the involvement in the case. Immediately they have found credible information regarding the involvement of the case. Both the arrested person were of the court red-handed. That means on the 25 morning, 8 a.m. they caught red-handed. But they has been forwarded before the special learned special on 26 after 28 hours, Lordship. And secondly, Lordship, column 3, suspected to be ganja, approximately 25 kg. But in their FIR, they have stated about 25.34 kg. And I have gone through the TCR called by this honorable court, wherein they have mentioned about 24.896 kg.
Kids.
All discrepancies are there. Moreover, they have in their annexure, the notice under section 47 of VNSS at annexure 3, Lordship. They mention about page 22, that is date and time of arrest 25/6/20 at 8 p.m. But they have forwarded in 26/6/25, Lordship. It is in NDPS case, how they have kept the person inside the without following the mandatory provision of the NDPS Act under section 50 and 41, 41, 42, etc. Lordship, I have specifically, I have enacted all the documents regarding he is the owner of the vehicle. He's not related, related with any materials. Only they recovered some materials from the passenger. But they have clubbed together and demanded some money, keeping the person inside the police station for 2 days, Lordship. Since morning 25 to next day evening, 26/6/2025. And it is a public vehicle which was plying the petitioner for his livelihood, Lordship. In this case, he has not related with any materials. It has not come, he did not know about any materials under possession of the passenger. It is not his duty, being a driver of the vehicle, to see all the materials where the luggage of the passenger, Lordship. And he has been more than 5 months in judicial custody, Lordship. And that regarding the that is not in under his conscious possession of the vehicle. Regarding the consent of search, Lordship, I am relying on the decisions of the Honorable High Court of Himachal Pradesh, wherein the Honorable High Court also relies on the decisions of the Honorable Supreme Court. This is the judgment of the.
Yeah, please. There was a, I'll come to you. Let me complete this.
Page 16, paragraph 22.
Yes.
May I read?
Yes.
Page 16. contention of learned counsel for the respondent that there was a violation of the section 50 of the NDPS Act, it is necessary to find out whether the joint consent memo and with respect to the communication of right available under section 50 of the NDPS Act is sufficient and valid in law. In this occasion, it is relevant and useful to see the judgment of the Honorable Apex Court in the case of State of Rajasthan versus so-and-so 2014 5 SCC 345, wherein has been held that the accused must be individually informed that under section 51 of the NDPS Act, he has a right to be searched before a nearest gazetted officer or before a magistrate, nearest magistrate. The nearest, the relevant portion of the judgment is as follows. Para 7, it is stated that in our opinion, a joint communication of the right of available under section 51 of the NDPS Act to be accused would frustrate the very purpose of the section 50 of communication of the said right to the person who is about to be searched is not an empty formality. It has a purpose. Most of the offenses under the NDPS Act carry stringent punishment, and therefore the prescribed procedure has to be meticulously followed. These are the minimum safeguards available to an accused against the possibility of false involvement. The communication of this right has to be clear, unambiguous, and individual. The accused must be made aware of the existence of such a right. The right would be of the little significance of the beneficiary, therefore is not able to exercise it for want of knowledge about its existence. A joint communication of the right may not be clear or unequivocal. It may create confusion. It may result in diluting the rights. We are therefore of the view that the accused must be individually informed that under section 15(1) of the NDPS Act has a right to be searched before the nearest gazetted officer or before a nearest magistrate. There was a gazetted officer, but he was the person who was in Nakachiki. And that second paragraph, Lordship, that is paragraph 23, similar iteration of law by the Honorable Supreme Court and found a recent judgment so and so. It is turn to page 18, Lordship.
Yes.
Last portion, page 17, last portion that 6. Where the right under section 50 has been exercised, it is the choice of the police officer to decide whether to take the suspect before a gazetted officer or magistrate, but an endeavor should be made to take him before the nearest magistrate. They have not been taken to nearest magistrate immediately. They kept accused person in 2 days in their custody. Police station. Thereafter, they produced the accused in the before the learned magistrate. Second paragraph, that is page 18, Lordship, 7. Section 50 is applicable only in case of search of person of suspected under the provision of NDPS Act and would have to application where a search was conducted under any other statute in respect of any offense. Then 9, Lordship, the burden is on the prosecution to establish that the obligation imposed by section 50 was duly complied with before the search was conducted. And paragraph 24, it is specifically mentioned as in the view of the above stated
Authoritative pronouncement of law.
before, the consent taken from multiple accused person by way of a joint consent memo do not meet the requirement of section 50 of the NDPS Act, as in view of the stringent provision of NDPS Act, each of the accused has right to be informed separately about his right to be searched either before a magistrate or a gazetted officer. But there is no consent memo. There is a verbal consent taken. It is also mentioned in the FIR. That is why there is no consent memo taken from the petitioner lordship. And he has no, he was not under conscious position of that the passenger has carried some contraband with in his inside his bag, lordship. Because he is only the driver and carrying the public vehicle, lordship. That we are considering all these because he has been since 2025 he has been in custody, and now trial has been going on, lordship. And he has some one minor child, ailing minor child in his house, and there is nobody to look after him also, lordship. He will cooperate with the investigation if, and will
Yes.
appear before the honorable court each and every date, lordship.
You've seen the record.
And a PESEL report I have seen, lordship, there is a confirmed ganja.
FSR also has come. The case is at the stage of trial is not
The
started.
trial, lordship.
The trial is going on. Oh, at the stage of consideration of charge.
I will appear each and every date,
What is
lordship.
the condition since?
Because I am not at all involved in the case. But then the passenger, he is carrying some materials. It is not possible for the part of
What
a
is
driver.
the materials regarding their linkage?
They may kindly peruse both the statement of my lord Hazrat Ali and other person, my lord. They are doing this business, my lord, several times.
Before the police, lordship, because
It will find the Abbas Ali statement, my lord.
And the quantity, what is by the inventory documents?
Quantity, my lord. More than 25 kg.
No, but
After the packets,
Yes.
it is not.
that it will be in
They
the.
cannot ascertain what amount they have recovered because
Should be in the-
they have stated in their FIR 25 kgs from 4
It can be
kg.
it will be a little less than that because of the packets.
Only because of
But whether it will be less than 20, which is
will
the
be less than
which is
50,
the which is the
Yes, it will be
commercial
less, yes.
threshold. More than 20 will be.
But, lordship, where is the linkage of that person?
linkage has to be seen.
In FIR itself, it is stated that he is the one passenger. I am not. I am only carrying the passenger. How it is possible for a person who is a driver to know about his luggage? The driver has no duty to search all the
that-
belongings before.
That is true.
That
That is
considering all these aspects, lordship, he will appear before.
that is
the-
why I asked these questions. Are there any materials to link, or he is
Yes.
just a stranger passenger?
No, it's not a stranger, my lord.
Stranger
Yeah.
passenger.
Yes, my lord. They are because they have hired. He is hired.
Of course,
Yes.
Madam is right.
Yes.
That they, if I
Yes,
suppose a Uber driver, I
only
hire,
that-
he cannot check my. There will be an argument if
That
he
will be
checks my
different.
vehicle,
That will be-
my baggage.
Yes, that will be a different case, my lord.
Yes.
But
It-
here, my lord, from the evidence of the
I am-
collected, my lord,
Mm.
it can be seen, my lord, they are both globe, hand in globe, my lord. Because from the statements of both the accused person, if you see, my lord, and from their position, it has been seized, my lord. And now it is a burden on them, as per section 35, my lord, that they have to show
Anyway.
how they have
Mm.
in possession of those huge quantity of, my lord, narcotics, my lord. And
Yes.
so far the decisions rendered, my lord, it is not fit to this case, my lord, because my lord, lordship will see from the FIR itself, it's a chance recovery, my lord. So all these decisions will not be helpful at this stage, my lord.
Consent memo is required. It is-
Anyway, I'll see. I'll.
Because, yes, ma'am, and so far, my lord, section 37 is also confirmed, my lord, it's a rigor that has to be passed, my lord. Because it's a conscious position and now it's a process of charged to him, my lord.
In my petition, I have specifically mentioned he is not in contrast
All the-
position.
All the notices.
And that is, and in the FIR itself, it is,
Notices, my lord, that is required, my lord, all have been there. I have flag marked, my lord.
See it properly then. Wait, I'll keep it for chamber.
Yes.
he purchased a vehicle on a higher
No,
purchase.
Because it is in a vehicle, suppose on hire, this linkage is very important because obviously,
Yes.
because every driver would be at risk otherwise, right? That linkage is very, very crucial actually. That they are partners in crime. It has to be, they have to be partners in crime. Otherwise, we cannot be.
Yes.
It is not practicable for a hire vehicle driver to check. There will be argument, as I said. He'll not hire the bill. That's true.
He has hired, I have specifically mentioned.
So this is there.
8,000, yes, I have mentioned.
Lordship will come to
CD is
lordship.
here.
A CD part, I have flag marked, my lord.
Anyway, so it is for chamber. I'll try to dispose it of today only in the
Yes,
chamber.
and it is under section 41, 42 will not be of help at this stage because it is a chance recovery. It will be section 43, my lord. So far, their concern is concerned, my lord. And section 50 also, my lord, there is
It is
specifically.
personal search. 43 is public.
43 is public, my lord. At the time of, my lord, when 41, 42 comes, when there is an information, my lord.
Yeah, information.
So that is.
So sometimes NACA is due to information also. Sometimes
but
it's a
my lord,
random NACA which
but
has
it's
a
a
chance
but it's a
recovery.
random stage.
No,
It's
that,
public, my lord.
they don't, did not
That will be there.
fly away from the place.
I'll see, madam. I'll
Yes.
go
Oblige.
through it properly. That's why I'm keeping it. See it carefully. Okay. Thank you. No problem. Tim.
This matter, Lordship earlier heard that he was not produced before the magistrate within 24 hours of his detention, Lordship. And that his notice which was served of his father, Lordship, under section 48, his father claimed that he never received that notice and the thumb impression affixed in the 48 notice, that is not his father's impression. And accordingly, Lordship, he submitted an application before the session judge that it may be sent for FSA.
Yeah, and he can say, I mean, thumb impression is thumb impression. Layperson cannot identify. That's why it's not exhibited. So, but there's only only an endorsement at the time of taking LTI of someone or RTI of someone.
Today, my lord, I have not the case diary with me, my lord, case diary already taken, but only the copy of.
Case diary taken back.
Yes.
Because there was a direction to retain the case.
How can I, my lord, retain the case diary? I will have to, my lord.
So there was a specific order from your lordship.
What is this?
This is the, my lord, earlier report regarding their, my lord, serving of notice and.
Yes, there was an inquiry. Now I
Yeah,
remember.
inquiry, yes.
There was an inquiry was directed, right?
Yeah.
So,
Inquiry
this is the report with regard to the inquiry.
No, it is the report of the IO.
IO. So let me see. Let me see the previous order, then it will be better. Session just Bhumi, no inquiry report. Not come. It has not come.
That report has.
Last
How come?
occasion, your lordship already observed that if the report does not come, your lordship will dispose of the merit case on merit.
Pertains to the commercial content. We had sent the copy of the order also
Yes.
to the CJM.
As per my instruction, lordship, that signature for the thumb impression and father's thumb impression already sent to the
Forensic.
forensic by the CGM.
CJM.
So, special messenger.
Oh. But
So,
CJM, if we get a report from the CJM, it will help us. And
Otherwise
let
also,
me
lordship-
read this first. What is-
otherwise also lordship may hear my case on merit, lordship.
This
and
case,
because there was a direction to retain the case diary, but without leave of the court, they have.
so
sent it.
I did not find any.
There was an order.
Case diary is available, so.
On 25th, and probably your lordship's order, it is there to retain,
23.
directed to the.
I did not find it actually. I don't know. Anyway, that's why they sent it back. Oh, yes, it is there on 411. Yes, yes. maybe retain anyway, so you have to get it
So,
back.
my lord, I have not gone through that.
You have to get it back then. Anyway, let me see this order, what is.
But otherwise, my lord,
Order.
within
Let me read
180
this.
days, my lord, I will have to. my lord,
Yeah,
try
that
to
is there
use
actually, so we should not hold
That
back.
is
also.
different aspect.
That
When
is
the
also true.
court specific order is there, they cannot
Yes, sir.
send it back.
Regarding that aspect, I will point out. my lord.
Intentionally uses.
And apart from lordship, that 48.
Just. Okay. So.
Yeah, apart from lordship, that 48 ground of 48 notice, lordship, I have also.
No, he has said that thumb impression was taken, but now how can we say it has to be forensically determined?
It is forensically, but apart from
Forensically
that, lordship,
determined.
my other grounds are also there. lordship, That
Then-
was not produced within 24
That
hours.
also is denied. That
No,
is also
he
denied.
cannot deny. It is a matter of record.
Record, but this, what is the date of arrest? 7/7/2025
No,
at 1:30 PM.
No, I am just.
No, it is, he has given the contemporaneous GD entry number also.
So lordship, may kindly.
GD entry number,
Yeah,
GD
lordship, may
number
kindly see
30 of 25, dated 6/7/25. Information received at 12:30 AM, brought to the police station at 3:30 AM, and thereafter interrogation. The
Yes.
contraband was recovered on
Yes,
the next day.
that time will be the time from when he was detained. I am having the Supreme Court judgment, lordship, that says, lordship, that time of detention.
No,
will
if
be
it is there in the case diary, it will be okay, but that's.
From the report also, lordship has seen.
And he has, investigation has revealed that his wife and father is also involved in the drug business. That is what he has said.
No, if,
So we have to see.
if father is involved.
That is, everything has to be balanced, right? No, they can, of course, they have a right to prosecute, but these are very serious matters, prima facie, isn't it? Liberty has to be counterbalanced with the interest of society. The society is spending so much money on the criminal justice system. They expect, minimization of crime. That is what the people expect from the criminal justice system. So both have to be balanced. Liberty is sacrosanct, no doubt, but the societal interest is also sacrosanct. Because ultimately the institutions belong to the people, not to us. We are custodians of the institution.
That I accept, but what my submission to your lordship is that they cannot misuse.
See, I mean, that is true. Otherwise, see, if 37, otherwise we'll have to go into 37. Otherwise, if it was intermediate quantity, definitely we could have taken a liberal view that, this some dispute is there about the compliance with the notice, then let him go, let the for the moment, and this forensic report, let it come. But now we'll have to, if you want, we can also, discuss about 37.
No, lordship, may kindly.
But 37 is always a tough, as you know, to
No,
well,
lordship, may kindly
good
hear me
counsel.
on the lordship, 24 hours ground, lordship. I am having that Supreme Court, I will.
You submit, definitely, it is a mandatory requirement under constitution.
Lordship, if that violation is there, then lordship, section 37 will not come. That is what the Supreme Court.
And then you have to prove, where have you stated exactly in your petition?
Petition, lordship.
Because there has to be cross-checked with the case diary. Diary is, you have to get back the diary. I'll need the full diary, because this has to be cross-checked. And forensic report, because the IO has specifically stated that the accused identified the certain person as the father, as his father, and thereafter his thumb impression was taken. Okay.
Can you have the CD, my lord?
No, scan copy.
Scan copy, my lord, because
Scan copy.
we've already
No, get the scan copy of the up-to-date CD as early as possible.
Up-to-date CD, yes.
Because of course, his concerns also have to be addressed.
yes,
As I said,
yes.
balancing both sides, both are equally important.
Yes, sir.
Both are equally important.
Otherwise, my lord, I would just like to point out one thing, my lord. Earlier in the trial court, my lord, accused was arrested, not on the point of 7/7/2000. Otherwise, my lord, I will have to also go through regarding purposive interpretation
And
of all these, my lord.
No, that you have to also, you also have to help
Bail
the court.
application earlier, my lord, filed before the trial court on 18/7/25. rejected on 29/8/25. At that point of time, my lord, this question they have never raised before.
Those were raised.
Before
Those
the
are
time.
in the rejection order also, those were.
Sometimes something may be mistaken rise also. It's not like pleadings,
Yes.
that's okay. That is
Those
okay.
grounds I have taken in ground number.
That's
14,
okay.
Paragraph 14, the 24 hours ground I have taken.
Kindly help me with the judgment also, and since a contention has been made, and it is our duty, and prosecution has to show,
Yes, yes.
because in that case, he can get over the challenge of 37,
Yes,
right?
yes.
Like 47, 40. I'll see it, don't worry. But, prima facie, a responsible police officer has said so. That is not gospel, but still, it is, we have to cross-check.
Supreme Court says, once I can prove that I was detained at a certain period of time, that has to be taken into calculation whether I was produced before the magistrate within 24 hours.
Yes, there is no.
So I am not relying on any controversial documents. I am relying on their documents itself.
And this forensic thing has to be seen, although here a police officer on record before a constitutional court has stated
Yes.
that, on being identified by the accused as his father, his thumb impression was taken.
Yes, but at the
But
same
it is
time,
denied by the other side. It is denied by the other side.
But at the same time, your lordship will see that notice page 55.
Yes.
Page 55, there is a column that Aadhaar card, PAN card, voter ID, Aadhaar ID specified. Those columns they have to fulfill. Whether they have verified that the documents which I am furnishing is the same person. It is their duty.
See, many stipulations have been imposed at the stage of arrest, and rightly so. But at the same time, we also cannot make it a, impossible hyper technicality. That, otherwise,
Your lordship has
forget about tackling crime. Otherwise, if we
Yes,
make
sir.
it a impossible hyper technicality, if I may use that word, expression.
Delivery of a letter, my lord. Suppose letter is in my name, somebody of my family is there in my home. Then, my lord, is because only my name is there, can my family members my lord, receive that document?
Anyway, so when can you get the scan? I'll look into it. Lord,
Here, in fact, in page 56, there is no signature of the arresting officer. Who sent this document to my family?
No, it has to, your
That's
lordship.
page 56, your lordship will see. No signature is there. No signature of accused is there.
no, this you'll be entitled to benefit of all infirmities if these are fatal
Your
infirmities.
lordship also granted
56.
who was in Mizoram and he was shown as a lordship receiving visit in Assam. Just few days back, your lordship
Yes,
granted.
yes.
So that
We
is
trusted the documents submitted by the petitioner side, of course, because we do not know. The date was on 14,
criminal
after he was shown, 2 days after he was shown arrest, but still we believed.
Facts and circumstances for every case is.
Because counsels are meant to be believed, they are officers of the court.
I will submit from the
Yes,
record itself.
sure. Sure. So these many contentions have been made, so these have to be, if your junior can help you, you can make it informally also, this points which you are taking, just make it will be very helpful.
I will paragraph.
Don't take
paragraph,
so much,
I will-
you need not take so much trouble, it's not final hearing of an appeal or something. Whatever it is possible, whatever is possible on your part,
That's it.
make a small,
Yeah,
informally you can submit, that will be helpful for me. In the meantime, let us get the scan copy early.
Yes.
So this matter has some contentious issues
Yes.
which need to be resolved,
Yes, bro.
legitimate grievances of people have to be addressed, the contentions have to be addressed. Accusation does not cannot condemn a person, even if it is a murder or whatever drugs.
Yes.
Can we better close the courts? Learned counsel, but it would have been helpful to have that inquiry by the court, our institution, but why it's not coming? I don't want to pass any coercive order, but it is necessary, that would have helped.
In that case also, my lord, report has to be.
Lordship.
So if my lord,
Reminder because.
No, if they have conducted any inquiry on their part by the court,
It is going on.
before
or
conducting.
going on, not complete.
Lordship that signature, thumb impression.
Oh, as part of that
Yes,
inquiry, it has
but
been
it
sent
has been
to,
sent
that
to
is
the
why.
Completion of that.
That is why they have not sent.
Yeah.
But that also they could have mentioned anyway.
Reminder
Everyone is very
Lordship,
busy, I
fix-
understand.
fix them next week, Lord.
Heard A. Ahmed, learned counsel, who reiterates his contentions, his primary contentions about the notice under section 48 BNSS bearing a thumb impression purportedly of his father, but which is actually not that of his father. Full stop. He has also reiterated his other primary contention that from the time of detention, the accused was produced before the magistrate beyond the stipulated period of 24 hours. Beyond the stipulated and constitutionally mandated period of 24 hours. Full stop. It appears that the case diary was returned back for the purpose of investigation. The IO has submitted a report dated 16/10/2025, where inter alia number 1, he has denied the allegations of inflicting injuries on the accused during his detention. Number 2, he has stated that thumb impression of the father was taken upon being identified by the accused. Number 3, denying the contention, he has stated that the accused was produced before the magistrate within 24 hours. And in this regard, referred to GD number 30 of 2025, 6/7/2025. Nonetheless, the learned counsel reiterates his contentions. The learned counsel expresses his disagreement with these contentions made by the IO. Full stop. So now we need not go into 37, right? Let us resolve these issues. Is that okay? Or should we?
24 hours is.
Should we? No. Those procedural aspects, we'll stick to that for the moment and not go into 37, right? Suppose those things are not in your favor, then we'll go into 37. Right? If 37 was not there, it was this would not detain us so much.
Yes, if I can
This
show
did
you a report-
this did not. If it was intermediate quantity, all these things can continue. But we could have taken it would have been easier to take a liberal view on bail. But since 37 is there, once 37 comes, initially even constitutional court is barred, right?
But if Lordship, I can show.
These matters are different.
Yeah. If
These
the
matters are
constitutional-
above.
If constitutional rights are violated,
Yes.
then Lordship,
It's
37 will not.
yes, rightly, right, you're very right. So issue call for the scanned copy of the up-to-date case diary. Bhathakur, can I keep this in a record?
Yes, ma'am. Then maybe
Keep a photocopy.
yes, I have the photocopy, my lord. Your lordship can kindly keep as a part of the record. Right. And my lord, latest status report of that inquiry, my lord, may also be called for from
From the court,
from the trial court.
trial court.
May I pray for
Therefore, and again, you might 1, 2, 3. Number 1, call for the scanned copy of the up-to-date case diary of so and so. Yes. Number 2, status report may be called for from the CJM,
From the CJM,
from the court of the learned CJM Sribhumi/Karimganj regarding status of the inquiry, if any, on the thumb impression purportedly of the father in the notice under 48 BNSS at the time of arrest of the accused person.
my lord, CD I will get, my lord, but regarding that report has to be called for by the registrar.
Registry will do needful regarding the report. And you get the scan copy. See, wherever this nowadays new judgment has been given 2 hours before this thing, this is fine. But manual, there, if you use technology for recording time, like now we can, record with all this Google and all that, then it is very safe. Manual process time recording is always vulnerable to manipulation.
That is there.
Always very vulnerable to
Therefore,
manipulation.
Supreme Court is observing that a CCTV footage in police station.
That's a great judgment. It's there because when I was in Jorat, the SP told me that they have very high-end CCTV cameras like here. It turns in the direction of, people who are speaking, but it's good. It's good.
So may I pay for that, that copy of report which was furnished by the IO so that I can address the timings?
Yes,
mentioned
yes.
there?
Yes, you have a right.
The rest may be
Sure.
directed to.
No,
furnish a copy.
on the prayer of the Learned Council, allowing the prayer of the Learned Council, a copy of the report dated so and so submitted by the IO may be furnished to the Learned Council. You have a
Alright.
right to see it.
All right.
Okay.
Next date.
Date, you work it out.
Lordship,
Sooner the better because of the nature of this
Yes,
matter.
on Tuesday, Lordship, 2nd December.
Tuesday, my lord, it will be
Be-
11th
because
of December.
Karimganj,
So 11th, he will get back to Lordship email. Lordship. Only he will scan copy.
No,
on
it's
the-
only-
fifth,
Email-
On 3rd or 4th, Lordship.
Fifth, my lord, on, my lord, 9th, my lord, 9th would be convenient because.
Because before
because
vacation, that
email,
will
my
get
lord, again,
difficult.
it will,
that week is, the pressure week will be last week.
Yes, on 4th or 5th. anyway.
Fourth, actually third, fourth, I will not be here. But
fifth.
will it be, it's not part third, but
On fifth,
on 8th, my
it
lord,
will be advantages because I am familiar with
on
this.
8th, 12, my lord, Monday, my lord.
Fifth or Monday?
Monday, 8th,
Fifth or Monday?
Fifth,
Monday.
Lordship.
He wants 50, you want 1. Then you have to resolve. I have no problem.
8th, 12.
Okay, he accommodated you.
Yes, sir.
We are all
Alright.
colleagues.
Right.
We should have best of relationships always. All right. 8.
Item number 11. May I please, your lordship? Lordship, LCR is there, lordship.
Yes.
My lord, full scan copy is not received. my lord.
Just a minute. This NDPS also?
NDPS, lordship.
You are for the DRI, madam?
Yes.
Lordship, it is 243 days and the contraband is suspected to be ganja and 860 kg, lordship.
We have to go on merits, 37.
Lordship, I have filed this petition on the contention of 48 BNSS which has not been served and I have flag marked there, lordship, in the TCR, lordship. In my record, it is on page
Let me see for your record first.
94, lordship, from my petition. '94 and 95 is the 47. lordship.
Yes. Grounds.
Before going below, lordship may look into the first 3 lines, lordship, which
Just-
is clearly
47 is okay, or is it problematic also?
47, lordship, although grounds are
This one?
grounds are there, lordship. Yes, 47, lordship. 95, lordship, page number.
Okay,
Although not all the facts, but
anyway,
basic
so,
are there.
so I'm on 94 now.
94.
Yes.
lordship. It
Tell me.
is, it has been stated under bracket, lordship, on 3rd para, lordship,
Yeah.
from the beginning, informed through mobile phone. Lordship, my contention here is that I have not received the 48, lordship. And grounds are also not similar. Lordship has already held in a
Commercial.
similar case.
Commercial quantity of Kanza, fabrication of secret chamber. Is guiding knowledge chips and contraband. 2 persons were arrested, right? 2 persons were arrested. And he is Surinder Kumar. Surinder Kumar.
And this 48 notice has been issued through mobile phone. They have intimated and he has acknowledged the receipt notice.
It has been sent through WhatsApp.
Through to a telephonic communication with her.
The content of the notice has to be sent through WhatsApp or whatever. It can be.
An IO objection already we have filed, my lord, in this regard. And in this report, we have found IO has mentioned that this particular Surinder Kumar, the accused person, has some other cases in Pathankot also. When investigation is going on, they have their team already also visited the Pathankot. Some three cases already registered in his name.
Any particulars of those cases?
Yes, ma'am.
Is it there?
Yes, ma'am.
Why I'm asking you this question, because one of the conditions of 37, as you know, is that he's not guilty prima facie and he will not commit any offenses while on bail, right? So previous cases could
Record may not give.
could be relevant to determine that question.
In objection, IO objection, it is on page number, I think.
Anyway, don't worry, I'll see it. It's okay.
I'm
So 47, they have given one paragraph,
Yes.
right?
And I'm
And 48, they have given 3 grounds.
Lordship,
Yeah,
that
given, but you said inform through your grievances, inform through mobile phone.
I have not received 48.
And
That
this,
is like-
whose signature is this? There is signature of
The
someone.
accused person.
This is the accused person signature.
Acknowledged it in his mobile. phone.
Surinder, acha, saw this. Surinder.
There is not, and there is no such acknowledgement of Lordship. Otherwise, because 48 has to be given to the family member. My contention is I have not received. And Lordship has also passed in a similar Lordship in an order, Lordship VA 415/25. The content of the 47 and 48 must contain all the basic facts. And 47 and 48 here, although I have not received, but are totally different, Lordship. 47 contains the fact, whereas the 48 does not contain the facts.
Yeah, the basic things are there, my lord.
Facts are not there, Lordship.
And in IO objection, my lord, have you read the paragraph 18, my lord? Objection of IOs.
Arrest memo, so let's see, what is that?
This one also.
Arrest memo was given to Rajesh
415 of the question.
Surinder Kumar. Witnesses. Arrest memo is okay. It has a sufficient detail also. Okay, what did you want to show me?
My lord, the paragraph number 18.
Objection. No? It starts from 97 page, I think so. Para?
Para 18, my lord.
I see.
May I read?
Hmm.
That's why the department humbly begs to state that there are 2 cases registered against Sri Surinder Kumar by the Pathankot and Jammu and Kashmir police. The details of the cases registered against Sri Surinder Kumar are case number 103 dated 31/7/2021 under section 1561 and 85 of NDPS Act, registered as PS division number 1 Pathankot at page 268 of Annexure CC. That is our final complaint. At case number 116/2018 under section 8 and 15 of NDPS Act, registered at PS Kazikum, Anantnag, Jammu and Kashmir. That is also page number 268 of CC, which is not in the TCA scan copy, my lord. The reports of the police station Naro Jaimal Singh is enclosed at the follow-up report Y DRI Act number J so and so dated 28/7/25 submitted by DRI Jammu and Regional Unit Annexure 6, page number 242 to 244 at para F, and email page so and so reported at 268 of final complaint so and so dated 25/9/25 submitted the court Honorable Dictionary Session Judge 3 Kamrup 1. So it is this accused person has already a case record of NDPS cases, Mela, in three number of cases.
He was, how was he, what is the story? He was apprehended in Naka or something?
Oh, yes, the special information from DRI, they have apprehended these 2 persons when they were coming from Tejpur to Guwahati for Goya.
Okay. They were going to Gaya and Bihar. And this much 860 kg of
Yes, ganja.
So at this stage, my lord, bail, if he will grant it bail, my lord, it will be a hamper for our case, my lord.
just a minute.
And he already stated in his statement that he has doing all these for monetary benefit, my lord. This is not his first case. In statement also he has confessed.
Merit, I think it's very difficult to make. The only thing, what is your contention on the notices? They're okay, notices.
Yes, my lord.
What receipt aspect? Contents are a little different, but I think it will pass. But still, about the receipt, I'm not so sure. It's not. He denies the receipt. But this should be taken.
He has acknowledged, his person has acknowledged. In front of him, it was communicated to the family member.
The contention here is that it should be in writing. Lordship and Lordship has held in one of its case, Lordship, that 47 and 48 to contain all the basic facts, Lordship. And here, Lordship,
I have not held
these
that
are
the
not
law
the-
of the Supreme Court.
these are not the facts, Lordship. This cannot be.
See, whether a particular notice, as I mentioned earlier today, whether a particular, in a particular case, the notice is sufficient or not is a matter of interpretation. It's a matter of interpretation. There you cannot have iron cast, you get my point. That notice, if it's there, whether, defense may say it is not sufficient. Prosecution may say this is sufficient. So that will be a matter of interpretation, right? So in my opinion, this may do. This in my opinion, the contents may be okay. Contents may be okay. 48 also, it is little different from 47, but still they have said the secret chamber is there, so and so. That's why you have to be arrested. That may do. That may do. The arrest memo is also of sufficient detail. All these may do, which is furnished to the accused. But I'm stuck with this contention that whether the family member got or not. Wait, can we show me it again?
Filed bail right after the arrest.
No,
In
where was the notice? 48 notice.
94.
94, that's from your petition, and from the records I want to see this. 94. These are very different. The IOs don't follow it properly, it creates a lot of difficulties. In 2025, now it is the time of, so it was in March 2025. Then it was not so clear at that time. Informed through mobile, signature of the addressee.
They have
Informed through mobile phone.
arrested on January, my lord.
If we apply substantive compliance, it may be okay. Depends.
There has to be acknowledgement of the one who have received, if it is received. My contention is that it has not been served.
No, because
And-
if it is sent electronically by WhatsApp, then how will the acknowledgement come? Blue tick is there. We know it's received.
Yes,
But how will they have to print out that?
that has to be there.
There has to be.
For that, my lord, I need some time for instruction from the department. my
You
lord.
take some instructions. You take some instructions.
If records are not in TCR, means.
You take instructions regarding this point. Otherwise, prima facie, in my opinion, the notices contents are okay. It will pass. Again, interpretation. He thinks it is not sufficient. He has every right to think like that. That it's not sufficient. Notice given, no dispute, but not sufficient. This one is given content. Okay, something is mentioned. It may be okay. Again, he is not satisfied, but we are stuck with this. 37 again, on merits, there seems to be considerable materials. So we are stuck with this point, that to what extent it was received, and how do we see it? Do we see it as compliance, substantial compliance, or insufficient compliance?
If there is an acknowledgement, then we will come to that point.
No, because actually informed through mobile phones signed by the accused. That also we can take. There also can be taken. These things cannot be generalized. Actually, it will depend on the facts. Actually, the ideal notice is where a notice is given and signed by someone's relative, nominated relative. That's the ideal. But in many of these situations where people are arrested, they are very imperfect situations. It may be on a hill, it may be on a Naka, sudden, you know.
Under that circumstances, if accused is given any paper lottery, he will
This is
make a signature.
there is always a turmoil situation and that kind of this kind of thing. I said merits it it is a hurdle. It is very challenging for him for merits. Anyway, kindly take the instructions regarding this.
9th of December.
Little earlier if possible. I leave it to you ultimately. Third, Mr. No, I know. Learned counsel and for the scan record has been received. Good stuff. During the course of hearing the learned standing counsel, NCB, right? This is. Right? Seek some time to take instructions regarding the conveyance of the notice under 48 BNSS to the family member. Stop. So you take instructions. We also have to be aware of the realities, because these are obviously if someone is being, detained in such circumstances, not in circumstances where on merit it may be very difficult to get bail, but these things they may be also. I'm not saying about this thing. In these situations, there can always be attempts to defeat the service of notice, so that this can be, this can be successful. This grounds defeat, the IO has to ensure that the notices are effectively given to the persons. You get my point, actually. So, which date? 9th? 10th, 9th, 12th. Should I keep it as part her? No, should I? Bail, usually we don't keep it. Let it. No need to keep it as part of them.
May it please the law. My lord, unusually I am mentioning matter, item 42, my lord.
42?
A criminal revision hearing. The other day also I mentioned, my lord. There is little chance of this matter of reaching, my lord. So
Today.
may I pray the matter may kindly be fixed on the 2nd of December.
2nd of December.
Yes.
Or the week after that. How about the week after that? Let it be on.
It's a hairy matter, my lord.
Yes,
If
yes.
it is kindly taken on the hearing day.
Hearing day, I'll
There
fix
is,
it.
there will be a chance of
It's an
reaching.
adjournment.
Old
MS
matter.
Rajar Bhuyan. Let it be on. So let it be on that Tuesday thereafter, 9th. 9/12.
Please, your lordship. Lordship, I'm also praying for an adjournment meeting. So.
Of
Item number 45, lordship.
45. Yeah, I don't know whether it reach, but anyway, okay. 19 matter. 6 and adjourn, adjourn as prayed for the learned council. And any date?
Yeah, date may fix for 4th of December, lordship.
No, don't take it next week. I mean, 4th, in any case, I'll be on leave. Take it next week. Thereafter, 19 matter, but still, it is old only. 16th December.
16th.
Okay. Huh?
Applies.
May it please your lordship, I beg to mention item number 38. My senior is not present for today due to medical emergency.
Oh, I see.
38 is along with 37.
So they are connected matters.
39.
You have to adjourn all of them together. Anyway, we'll just record your prayer. Probably it may not reach also, I think. Okay. So we'll try to accommodate. In any case, unlikely. But they are together. One date will be there for 37, 38, 39. Right? We'll take it later. Yes. Yes, last name, please. Yeah, nothing to
22 time being.
It's the day.
This case, my lord. Nothing, my lord, in the. I have gone through the CD, my lord, and the inquiry report, my lord. There are 2 inquiry reports available in the CD. That was dated. Inquiry reports. On the other hand, till now, there is no any evidence has found against the allegation mentioned in the FIR by the complainant that alleged party stated so and so, that is the my lord. And regarding data, and I would like to point out one other aspect, my lord, regarding here in the FIR, your lordship, I would like to point out.
Page 30.
Page 1,
30.
30, my lord. Here the informant has stated that at that point of time, one Midul Hazarika, my lord, he was driving the vehicle.
Yes.
But in the FIR and the case diary, I have found that Midul Hazarika, in fact, actually not driving the vehicle at that point of time. One Monu Das, my lord, at that point of time was driving the vehicle. His statement is also available. And my lord, actually, my lord, the vehicle is hypotheticated to one's finance company.
Right.
And thereafter, he rented the vehicle to Midul Hazarika. And on that day, vehicle was, my lord, driving by Monu Das, driver of Midul Hazarika. And from his statement, my lord, his statement is also available, statement of Midul Hazarika, and along with Sonu Sinku Das, my lord, driver, one Indrajit Das was also available at that point of time. His statement is also available, but in their statement, they have not said anything about saying all these, my lord, words. So, my lord, why he has stated in that affair regarding Midul Hazarika, otherwise the informant was also not present at that point of time.
He is also not present.
Not present there. So, my lord, prima facie, it seems that regarding that provision.
Other aspects, okay, let the investigation go on. Because this,
At this stage only.
since maintainability has to be seen. To Albert order to what is it? Yeah,
Page 147.
15/10/2025. That means fair. Did I know? You'll go first. 1, 2, 3. 4. 5. 6. 7. 7. And 8 also, yes. 8 all I would have reference. The petitioner was granted interim bail on 15/10/2003. And case diary was called for. The case diary has been received. The learned additional PP, Mr. Bothakur, has confirmed the contention of the petitioner side that at the relevant time, the petitioner was not at the place of occurrence. In the meantime, another inquiry report has been prepared by the IO. The full stop, the same along with the statements of the concerned persons, including the ones in the vehicle, are stated to be available, and it is submitted that these do not reflect any casteist slurs or casteist slurs as alleged in the FIR. Therefore, I am of the considered view that as regards the SC/ST Act, the present bail petition will fall within the limited window provided in the case of Sergeant Scaria within bracket Supra. Full stop. As regards the other offences, it appears that there is progress of investigation. And his statement has been recorded, and his statement has also been recorded pursuant to grant of interim bail. And I do not find any necessity or justification to cancel the same. Full stop. Accordingly, the interim bail is hereby made absolute, subject to the condition that he shall cooperate with the process of law and not hamper or tamper with it. Return back the case then bail petition stands as posted. Okay? Yes. Time being as well, no?
27 time being.
Yeah. Yes.
Yeah, please. Let's say, as per my information, search sheet has been submitted. in this
Submitted.
case also.
Otherwise, allegation is a bit serious. Dacoity or something, not dacoity, robbery at night.
48 received,
Okay. So you, according to him, charge sheet has been submitted. Interim order is there. Interim order is there. Let it continue then. Then you get the case diary.
My lord,
Get the, since the allegation is a little on the serious side, let's get the learned petitioner counsel submits that as per his information, case has been charge sheeted. However, the case diary or any such communication is not received. We'll get a scanned copy of the.
my lord, he submitted that subject submitted already in this case, my lord. Regarding that, I have no instruction.
Yes, yes, sir.
Interim is there. let
Reflected
him
there.
appear
No, that will continue.
Yes, my lord, let
Or
him
would you like to approach the
before the trial court, my
trial
lord.
court? What sections are there? Arms. It will be before magistrate now. I don't know whether there'll be any bar.
So it's pending before judicial magistrate. First
Only
class.
till the date of appearance, otherwise.
Will the magistrate, can the magistrate grant bail? Sessions Tribunal section. When 27 is Sessions Tribunal or Arms Act? It's a serious section actually.
Maybe session prior.
It's a serious section, 27. Maybe Sessions Tribunal, maybe.
Then
Very-
let him get the scan. copy.
Yes. The interim shall stand extended till the next date of listing. In the meantime, call for the scanned copy of the case diary and charge sheet if available. You can give a longish date, first week of January, after reopening.
Yes. Well, it may be recorded that he submitted that subject.
Yes.
Yes. From the court of CJM Dhemaji.
CJM Dhemaji. Take the date. 5/1, 5/1, no? 5 January.
65 time being.
It was seven. It was seven. It was seven. Acha, this matter, no? This poppy seeds, no?
Yes, it. There are two Caesar, I'd just like to point out your lordship, my lord. There are two Caesar lists available in the case diary. Here, from the residence of Lal Mia Bonia and the present petitioner, my lord, along with those 12.307 kg of suspected to be opium poppy seeds crushed, recovered. And thereafter, one Caesar list also available, my lord, from the present residence of the house of the present petitioner, my lord, Lal Baksa Mia, 50.33 gram of suspected to be opium, but there is no specific whether this is poppy straw or poppy.
Opium is, it is
Yes.
listed separately.
Yes, my separate.
I think it is listed separately. Let us
Yes.
cross check.
These are the two Caesar lists.
No, there are two different persons.
Yes, yes.
Two different persons.
The present petitioner is Lal Baksamia from his house, my
Poppy
lord.
seeds.
Because the house is of the my lord, present petitioner and Lal Baksamia, and one another, my lord, all are brothers, my lord. One, my lord, Somirul Bunia, at that point of time, these accused persons were not present at their house, and from their brother Somirul Bunia is also their brother. All are brothers. From their house, my lord, but two premises, one
Lal Baksamia. Bania.
not only poppy seeds, my lord, from other Caesar list, it reflects that opium, my lord, also whether that is straw, seeds, my lord. Otherwise, entire poppy.
Yeah, do you have the NDPS Act? No? Do you have the NDPS Act?
Yes.
And you kindly see the chart, the schedule. Opium, see opium, poppy seeds, the case law we have seen, it does not fall in the NDPS Act.
Poppy seeds, my lord.
Opium slash poppy seeds crushed.
Here.
So and so was
And
found.
alkaloid is, my lord, morphine from poppy seeds, my lord, ultimately FSL.
Yeah, poppy seeds, recovered suspected only. On the present petition, opium was said to be seized, right?
Yes.
50.33 grams of opium. Opium. Can you see the listing of opium?
Only FSL result will confirm whether the morphine.
Lal Baksamia. Samirul Bania, it was found to be
Yes.
poppy seeds. Poppy seeds. 12.918 kgs of poppy seeds. And from the present petitioner, Lal Batsa Bania, 50.33 grams of opium. So you have to see
Entry
the
number
listing.
92 is the opium, thereafter opium derivatives, and my lord morphine is 72.
Serial number? Serial number 70. Opium is 25 grams and 2.5 kg. 25 grams. So it is intermediate quantity. Opium is intermediate quantity.
Intermediate. Case is registered under 20B, 21B.
Oh, rightly, it's okay. But learned counsel, your senior had submitted that the whole submission was with regard to poppy seeds,
Yes.
right? But it seems that poppy seeds were not recovered. From him, this opium was recovered. Can you help clarify that from him? Because the submission was all that poppy seeds is not. Do you want me to wait for him to clarify this? Wait for today?
Then tomorrow, my lord, if instruction to.
If your Mr. Dotto is around, then we can take it up today also.
Yes.
After some time, because the whole submission was on basis of that. So anyway, you tell him that as per the, if I've seen it correctly, the petitioner,
Yes,
it's opium.
Yes.
From the other person, opium, this poppy seeds. Poppy seeds, not NDPS.
Your lordship may kindly go through the my lord FIR, my lord. And from the
That's
house
from
of-
the FIR only.
They are all brothers. Your lordship may first seizure list also Lal Batsa Mia, Lal Mia Bania, and my lord Samirul Bania. All are my lord.
True.
Yeah, two different premises.
What is the other Caesar list? This is the other
next,
Caesar
my
list.
lord, from
Lal Batsa Bania. This Caesar list is
That
relevant to us.
In the same my lord house.
Total of
but two
50.3
premises.
is suspected to be opium. Packed in a black polythene.
Yes.
When was he arrested?
Arrested on my lord.
I can dispose it of also. I can dispose. Oh, I anticipated. I think. Should we wait for your senior? I think it will be fair, because the whole submission was based on that. If he's around, then you tell him that is the thing. Otherwise, if he has gone, then tomorrow we'll tell him. Oh, there's Gary. It was production. Production is
Your lordship.
Your Lordship, this is a charge system matter, Your Lordship. The last occasion, Your Lordship, instruction was given to public prosecutor
That,
regarding whether my name has been sent for trial or not, Your Lordship.
okay. Charge sheet is there, no? Oh, whether it was sent off for trial or not. That is not clear. Have you received some communication?
Yes, well, I have received the communication. Javed Ahmed, well, he. Yeah, I reported the above mentioned only going to submit charge sheet, and Sri Javed Ali.
You're Mr.
Yes, against him.
Your good name, please?
It's Enmili.
And counsel, yes, he has been sent up.
Yes, Javed Ahmed alleged Javed.
Okay, investigation is completed, so I think.
Direction will be given, Your Lordship. Direction will be given, I'll appear.
It's okay, I'll dispose it of the section. Then you can submit fresh bail bonds there. 482 bail application seeking bail for Javed Ahmed in connection with Jorat PS 233 of 25 under section 21B 25 of the NDPS Act. Full stop. The allegation in the FIR is about recovery of intermediate quantity of suspected heroin from the possession of the accused. The case recovery of intermediate quantity of heroin. That's all. Full stop. The case is stated to have been charge sheeted, and the learned prosecution was directed to procure an instruction as to whether the present petitioner has been sent up for trial. Full stop. In this context, the learned additional PP submits that the petitioner has also been sent up for trial in the charge sheet. In view of the completion of investigation, I allow this petition and it is directed that so and so 25,000 with 108, subject to the condition that he shall be available for trial if one commences and shall appear before the learned court below as and when required, shall not hamper or tamper activities. You can submit and fresh bail bonds.
Definitely.
The bail petition stands disposed of.
Is that, my lord? In case of Your Lordship, may direct him to appear before the trial court on that?
That will be a condition.
Yes, otherwise, without my lord producing the materials,
Completion only on this
Yes.
ground, not given. Completion of investigation.
I'm sorry, I think 65, taken tomorrow.
Oh, no problem. Right to लिखी दी वो चलो. This was the third NJ doctor additional PP. Case diary has been received. We'll stop. This is the matter tomorrow. Case diary be written. Tomorrow.
Item number 12.
Russian list. The party to timing. Yes.
Made clear. This is second bail application, Lordship. Earlier bail application was filed during investigation, Lordship.
Yes.
And that order, Your Lordship, will find page 22. The petitioner before Your Lordship is the owner of the truck or vehicle which from which Lordship the arrest contraband was recovered. But while recovered at the time of recovery, the owner was not there. Driver and handyman were there. They were carrying the contraband, Lordship. And subsequently, the present petitioner, who is the owner, he was also arrested and forwarded. And during investigation, that submission was made and it was relied on, and Tufan Singh was also relied. And Your Lordship's observation, Lordship will find at paragraph 15.
Yes, I remember this.
Yeah, it was paragraph 15.
Investigation is in the meantime completed.
Completed and that material is sent. That in fact, Your Lordship will see the charge sheet I have enclosed. That relevant part I am taking Your Lordship to page 41.
Diary has come?
Madam, it is ECR has come.
ECR has come.
ECR certificate, madam.
Yes, 41.
Page 41. And at page 40, just one thing I'm pointing out, that contrabands, these are the things recovered, Lordship. That vehicle, contraband, and then material, your Lordship, will be on page 41, top portion. That phone numbers were there, serial number 3 and 4. That phone number belongs to some other person, not the present petitioner, Lordship. That one belongs to Semimuddin, that page 41, third line from top.
Yes.
And thereafter, Lordship, one phone number, two phone numbers that belong to Tanzil Abedin Talukdar, that is different person. And those CDRs were collected and they were in contact with each other. Regarding present petitioner, nothing is found except, Lordship, that he is the owner of that vehicle. That your Lordship will find during investigation.
Yes,
report.
I've got it.
Yes.
You can read.
During investigation, the PO was visited and drawn up the sketch map of PO, examined the compliance and other available witness person, and recorded their statement under section 180 BNSS. In course of investigation, a huge quantity of narcotic drugs contraband suspected to be Yaba tablets, approximate 80,000 numbers of gross weight, total 8,576 grams, that is 8 kg 576 grams, were recovered and seized from active joint possession of arrested accused persons at the PO. So present petitioner was not there at the PO. He was subsequently arrested.
Secret chamber.
Which was being concealed within the secret chamber of grey box of the vehicle registered number sensor. It came to light that the seized contraband of drugs suspected to be Yaba tablets are being illegally transported from Mizoram, bordering Indo-Myanmar side of Mizoram state of Sribhumi, Assam, conspired and associated with the owner of the seized vehicle, namely Abu Muhammad Tanjir. So now they have to show how I am associated, Lordship, and on whose instruction and investment they have been engaged in often transport such type of narcotic contraband with this vehicle. Accordingly, based on the receiving of information arrived at the PO at the sensor, this paragraph is not relevant, Lordship may skip that paragraph. It is to be noted that the arrested accused persons, namely Semimuddin Bag and Tanzil Abedin Talukdar, are the veteran and kingpin of drug trafficking, and who also has been conspired in transporting of drugs from Indo-Myanmar side of Mizoram to Assam Sribhumi district as their usual business of earning illegal money. And whereas the arrested accused person Muhammad, namely Abu Muhammad Tanjir, is the owner of the seized vehicle. So this is my implication also. Who is the main felicitator and financier of the smuggling of drugs from Mizoram. So now here I am just pointing out to your Lordship that 27A is not there.
Not given.
Not given. Because there are no
But
material.
this allegation is about 27A, but
Yeah.
that section has not been.
Not there because they have not found any material to substantiate their allegation.
Fine.
Sribhumi district for illegal business since long day. Accordingly, on the strength of FIR, the accused, namely Semimuddin, Tanzil Abedin Talukdar and Abu Muhammad Tanjir, were arrested and forwarded them to judicial custody. So I was arrested on Lordship 11/6/2025. FIR was lodged on 16/3/2025. That is about after 3 months. Still they arrested me only on the basis of the FIR. No material has been found. And after filing of the charge sheet also, the scenario is same.
I see.
Now next year, Lordship will find in course of investigation the inventory report. It is there. That last line your Lordship will find of that paragraph. Report of seized vehicle belongs to arrested accused Abu Muhammad Tanjir. So that is not disputed. In course of investigation, CDR, call records of users and so SIM number so this two phone numbers your Lordship will get the names top, which I have pointed out, page 41 top. This belongs to Lordship Semimuddin Beg and Tanzil Ahmed Talukdar. These two numbers were collected from the Cyber Cell SP office Karimganj through PS email and analyzed and found frequent call contact to each other. Upon meticulous analysis of SDR, CDR, PTR of phone numbers belonging to the arrested accused persons and found some unsuspected numbers to which accused persons called several times at the date of incident. In this connection, collected the CAF details and suspected numbers. After that, CAF details were thoroughly verified and was found that the numbers are belongs to another unknown person of another state, but accused person stated that the numbers belong to their occupants, those persons which help them transportation so and so and so. So FSL report so and so.
No.
So this
So
is
now investigation is completed, right?
investigation is complete.
Now we have the complete picture
Yes.
in a way, yes, because as far as investigation is concerned, further investigation, another matter. So now on the basis of this almost completed picture, we have to see what are the materials apart from the statement of co-accused.
Yes, my lord, that is what I want to say, my lord. First, my lord, there is a hall of almost, my lord.
Oh, then no doubt.
80,000.
Very
My lord, that
serious,
is- that is-
very, very serious, yes,
And
no doubt.
also, my lord, regarding the vehicle which has been used, his vehicle, that is also not in dispute, my lord. This is the second question, my lord. Now, my lord, and thirdly, from the CTR analysis, it has been found that there are frequent contacts with the persons whom the accused has made their name, my lord. So they can use some other SIM. That cannot be. That is not a problem, my lord. They will use a SIM of others and make contact with the facilitators, and afterwards say that these are not my numbers, my lord. This cannot be, my lord. Even there has to be some my lord, rational basis to find, my lord, because their occurrence,
Section
their
is, what
presence
section
are
is
there in the
there?
place of occurrence, my lord.
22C,
Just
25.
the names are
page
not there
40.
in the, my lord, in the
Section
names are
term,
not there in the SIM card, that they are said that they are not the persons, my lord. Why will say they the different thing, my lord? So that at least in that way we have to proceed with the investigation, my lord. They can very well take a number of some other persons, my lord. This is a very simple thing. They are modest, my lord. Your lordship can see, my lord, that they have the other persons from whom the drugs were seized, my lord. Specifically, they have name, my lord, and there is also presence of those persons, my lord. SIM cards, my lord. So now the trial has begun and search is not yet framed, my lord. And going by the my lord, amount of my lord seizing materials, my lord.
Just a minute.
Other things, if you lost, there is a record, my lord, I have flag marked some relevance. Now the burden is on them, my lord. They have to show that they are not present at that place of occurrence, my lord. And another thing, my lord, my understanding says it's section 27 not in it, but there is section 29, my lord.
Okay, I'm just reading the previous order, which is a bit long. Anyway, so the materials, what are the, so to sum up, what are the materials according to you? The diary it is not there.
Has
I
there.
think it's
It is
there.
there.
It is
It
there.
is there.
Like, trial has progressed.
No.
It's started.
Each has
Yes,
stage of
he-
my
and
copy.
He's in custody since 11/6.
Yes, Lordship.
11/6. Trial, the
And charge sheet
examination of witness is not
sub-
started.
Not, sir. Charge sheet submitted on 9/9/25.
Okay. 9/9. Do we have the charge sheet here?
Yes, that is page 29.
Okay,
That
okay.
already I have read before your lordship.
Yes, yes. Sir. This was not there in the earlier bill,
Earlier,
right?
that
How
was-
many listed witnesses are there?
Listed witness 11.
11. Not much. Can be completed. But that's not the issue.
But I'm just relying on two judgments, one of Supreme Court and one of our coordinate bench regarding the 37 lordship and that co-accused statement lordship.
No, that's okay. The legal principle, you can submit. The legal principle is clear. No issues. You know, that a determination can be made. But now the facts have to be clear. What are the materials? As you said, CDR analysis.
CDR
What are the materials? That will be my specific
Yes,
query.
that is very specific.
Query to myself and to the prosecution.
Yes,
that
sir.
what are the materials?
That is-
Leaving aside the statements of co-accused.
Yes, these are the materials what I have submitted, my lord, that their presence are, that the presence of those numbers are there in the place of occurrence, my lord.
Hmm.
They are now saying that they are not. they are
And no,
not
the presence of the persons found in the vehicle, their numbers were found there at
their
the place of
number-
occurrence.
Yes, yes.
And this person,
And this person, my lord, the name given by the persons from whom the contraband has been recovered, my lord, they said that these are the names of these are the persons who have made contact with them. And that has been proved from the CDR. But only one thing is when they are taking the plea, my lord,
different
that
number.
numbers are not in their name. That can be, my lord, it's a very good technique, my lord.
But that,
They will
that phone number is not mentioned here, Lordship. How he can say that I am taking that plea? Lordship may kindly see the FIR. In the FIR itself, they have mentioned the phone numbers, page 16.
It's not very
These
clear.
are the phone numbers which are mentioned, Lordship.
I'm reading from the search sheet.
Yes, but charge sheet and FIR same,
I'm
Lordship.
saying
These are the phone numbers which
his
they have
submission.
seized and they have sent for FSL. Nothing else they have sent.
Lordship, may
I think if they have the CDRs, Lordship, they could have identified that from my phone number, who are the persons
Is
called.
are you sure the entire contents of the case diary are here in the record? I don't think so. This will not be so,
yes,
because
not it-
without the CD, it will be difficult.
not exhaustive, man.
Not the entire CD will be necessary.
Right.
That's why I specifically mentioned when I call for scan record, entire case diary and the charge sheet.
Yeah.
Charge sheet, of course, he has also annexed.
Yes,
It
yes.
is here also.
Yes.
Charge sheet is here, no doubt.
Now the materials is.
In these
only the-
cases, actually, ideally, the IO should specifically state
Yes.
accused one, these are the matters.
These are the-
Accused two, these
yes,
are the
yes,
matters.
yes.
That much, if
that
trouble,
has
that
to be,
much,
my lord, for the
that
convenience,
much
my lord.
trouble if they take, it will be
Yes.
very helpful for to determine this
For the
kind of questions.
Convenience of the court also.
And everything, framing charge, everything. And what, this judgment of our High Court, 20
First one is Lordship, that Supreme Court.
relevant paragraph,
Relevant
Supreme
paragraph.
Court judgment, let us see first, Supreme Court judgment.
That's,
This judgment,
Supreme Court judgment, Lordship may kindly see that paragraph 8 and 9.
January 2022,
Yes.
paragraph 8 and 9.
So in that case, Lordship, High Court granted bail, Lordship, and that order was challenged before the Supreme Court.
Para 8, right?
Para 8 and 9.
You want to read or should I?
Hello.
read it?
While order dated 5 January 2020, the learned counsel for the petitioners NCB were directed to prepare a comprehensive tabulated statement with respect to the role attributed to
Yes,
each
this
of
is
the
what I was saying.
respondents.
This is what I was saying.
Yes.
This really helps.
Yes.
Hmm.
The evidence gathered against them at the time of their arrest, their antecedents, the dates on which they were arrested, and the period of custody undergone by them. For ready reference, the said tabulated statements has been filed and a perusal thereof reveals that, so shall be association number, heavy reliance has been placed by the petitioner NCB on the voluntary statements of the accused and the co-accused recorded under section 67 of the NDPS Act for arresting them. Another piece of evidence referring to the CDR details in respect of A3, A4, A5, A6 and A8 in the first case, which as per the prosecution goes to show that the said respondents were constantly in touch with each other and with A1 and A2 on the date of seizure. The attention of this court was also drawn to the fact that the antecedents of A5, A6, A8 for in the first case, the A2 and A5 in the second case are not clean. Having gone through the records along with the tabulated statement of the respondents submitted on behalf of the petitioner NCB and on carefully perusing the impugn orders passed in each case, it emerges that except for the voluntary statement of A1 and A2 in the first case and that of the respondents themselves recorded under section 67 of the NDPS Act, it appears prima facie that no substantial material was available with the prosecution at the time of arrest to connect the respondents with the allegations leveled against them of indulging in drug trafficking. It has not been denied by the prosecution that except for the respondent in SLP criminal so none of the other respondents were found to be in
The bail
possession
granted was not overturned.
Yes.
The bail
So
granted
Tufan
was
Singh
not
was
overturned.
So Tufan
overturned.
Singh, yes, Tufan Singh was released.
We have discussed this earlier also. Tufan Singh obviously is very clear. No
And it is-
conviction on the basis of post statement of co-accused, which actually follows from that accomplice evidence, which needs
Yeah,
corroboration,
yes,
which is in the evidence act. But I may have missed something. But as far as I know, we still do not have any pointed decision to say that if the only material is the statement of co-accused, he has to be granted bail. I think this is an important factor to be taken into account. But if you find such a judgment, certainly we should know it. We should read it. But it can be taken into account. There's another aspect, that very fact that that conviction cannot be based upon the statement of co-accused. If that is the only material, then perhaps in 37 you can make that determination.
Yes.
That he's not guilty or he's not likely to be guilty.
Yes, that is
Maybe.
what observed in the.
Maybe.
the
So,
current
but
bench also.
the handicap I am facing here is that the complete set of CD
And
is
even
necessary.
Lordship,
Should we ask the IO to prepare a, because they are also very overloaded. We are everyone. I know that.
So even Lordship just
Before the, because after search sheet, my lord, they have
If we can prepare, actually in serious cases that should be done. Which was what are the materials
That one can point
collected.
out if anything is there against me, Lordship.
Or you can also study and
Yes,
study
point out.
some more time. But is this sufficient? Because these have voluminous CDs.
the
The entire CD actually we need it. The scan copy.
entire scan copy of the CD.
No, if you can prepare on the basis of this, then it's okay.
I'll, yes,
Or should we? It's better. I think we should.
better.
Because this is an important determination.
Yes.
Suppose there are other materials, then it may not be. And what is this High Court decision? What did they say?
That is also Lordship. There was also only that.
Relevant paragraph. Have you noticed?
19, 20 and 21.
Let's see. Where is all of the charge sheet?
Reported everything. Yeah, it starts from 17, Lordship. The Supreme Court judgment was quoted. Further.
It makes.
And what is reasonable ground, that is Lordship discussed also here in this case.
Yes, yes, is not guilty can be taken as will not be guilty on the basis of materials. Anyway, that will be, we only have the charge sheet, but we also need the supporting materials, actually.
So, my lord, regarding the section 67, my lord, that has led to the Tufan Singh judgment, my lord. There is a clear, some observations are made in the decision. I am just relying, my lord, just 2-3 lines I want to read from this, my lord.
Yes, you can.
Yes,
You can read it.
And Mohit Agarwal in fact referred to the judgment of coordinate bench which I have placed there.
Yes, yes.
Yes.
I just mark it as your judgment. Because these matters need, time to.
Yes, ultimate kindly, paragraph 17, my lord. Just I want to.
Yes, you can read
my
it.
lord, because my lord,
Read.
161 and 67, my lord, these are, my lord, sections introduced, my lord. Otherwise, there would not have been these sections, my lord. If
Yes.
there is no value at all, my lord. So what it says, my lord, paragraph 7, even the confessional statement of the respondent and the other co-accused recorded under section 67 of the NDPS Act, which were subsequently retracted by them, the other circumstantial evidence brought on record by the appellant NCB ought to have been dissuaded the High Court from exercising its discretion in favor of the respondent and concluding that there were reasonable grounds to justify that he was not guilty of such an offense under the NDPS Act. We are not persuaded by the submission made by the learned counsel for the respondent and the observations made in the UP order that since nothing was found from the possession of the respondent, he is not guilty of the offense for which he has been charged. Such an assumption would be premature at this stage. In our opinion, next paragraph, in our opinion, the narrow parameters of bail available under section 37 of the Act have not been satisfied in the facts of the instance case. At this stage, it is not safe to conclude that the respondent has successfully demonstrated that there are reasonable grounds to believe the criminal offense such and such, and that he is not guilty of the offense alleged against him for him to have been admitted to bail. The length of the period, that is also important, my lord. The length of the period of his custody or the fact that charge sheet has been filed and the trial has commenced are by themselves not consideration that can be treated as persuasive grounds for granting relief to respondent under section 37 of the NDPS Act. And accordingly, the bail is set aside, manner. This is a three-judge bench.
In this case, Lordship, the other circumstances were not considered, and that other circumstances leading to discovery was there. If that is that is in my case, they can place that facts. I will not argue that a confessional statement is.
Already, I am relying on the principle, my lord. This case, my lord, leading to discovery, but here already the materials were seized. Thereafter, their name has come, my lord. So on their statements, two-way, my lord, the statements. One, in one case, statements relating to the discovery of the contraband, and another case, my lord, contraband already discovered, but it was led by the co-accused statement. Two are maybe separate, but both lead to the statements of statement taken under section 67, my lord. Those were taken really.
How that can be equated, Lordship? That is what they is clearly defined in section 27 of the Evidence Act. How leading to discovery has to be treated. That cannot be equated with confessional statement and the person who is arrested after 3 months of the incident, Lordship, and recovery of the contraband.
I am not saying that.
Let him place before. Let him place before.
Learned counsel for the petition. No, it's okay. I have always believed that we should always be courageous to face facts. Facts are facts. If it's the materials are there, interpretation is different. But this Tufan Singh principle, I am just reiterating, it is just actually flows from that section of Evidence Act that accomplice evidence needs corroboration. Now in BNS, BSA, it has been framed in more clearer language that it requires corroboration.
Yes, then I will not say that this will lead to conviction. I am not on the conviction.
No, that is not, because see, now we are with regard to the principle of Tufan Singh and 37.
Yes,
This thing. So let us have this thing. But since we should not, this has been already pending, so.
Just want to relay that.
Learned counsel for the heard learned counsel who also submits 2 case laws, also heard additional papering, who submits a decision of the Honorable Supreme Court. Stop. The case has, in the meantime, been an earlier bail petition was rejected by this court on 6/8/2025 in BA 2070/2025. The accused is in custody since 11/6/2025. Stop. In connection with Karimganj PS case number 134 of 25 under section 26, it will full stop. The same is presently special NDPS case 28 of 25 pending before learned additional session judge Sri Bhumi / Karimganj. Full stop. The petitioner is stated to be the owner of the truck where the alleged contraband was found, and the occupants of the vehicle were arrested and other co-accused, right?
After 3 months, he was.
It is submitted that the accused, the present accused is stated to have been arrested 3 months after the date of occurrence. Full stop. As the case has been charge sheeted and the investigating officers collected the materials of during investigation, the question before the court is as to whether there are materials against the petitioner apart from the incriminating statements of co-accused, so as to make the determination under section 37 of the NDPS Act vis-a-vis the principle of law laid down by the Honorable Apex Court in the case of Tufan Singh versus State of Tamil Nadu. Citation to my division. It was 2021 4 SCC 1. Though scan record has been received, but it appears that the complete materials which are necessary to make the aforesaid determination are lacking. Therefore, the call for the scan copy of the entire case diary. Charge sheet we already have, no need, no need. Scan copy. Scan copy of the entire case diary may be called for.
From the court of special judge.
Photo, yeah, additional session plus free bond. Date, you kindly work it out.
Eight per nine. 8 per 9. 8 lost.
Hmm?
8.
So if you have these interactions, no, I mean, when you with the IOs and process figures, you encourage them to do that, because see, the thing is that if he's doing while he's collecting the materials at that time, preparing that kind of thing is easier. You know, it's part of the same homework. But later again, he has to go into it, refresh it, again prepare it. While doing it, it's easier. So it is very helpful for defense also, that these are the materials found against me. So for everything at all stages.
There is a Supreme Court judgment which mandates that IO should mention every materials in the charge sheet itself.
This judgment?
Yeah, no, this judgment, another judgment I will place before your
It's true.
lordship.
No, it's,
There is a direction.
I mean, there are various kinds of cases. In
Yes.
simple cases, because they are also very overloaded, we have to say law and order duties and all. So that will be in serious cases, it will be really helpful if they do it. So 8-1, 8-12.
8-12.
At least in this
All
type
right.
of cases.
Yeah, where there are more materials and these kind of issues.
Issues, man. I'm deeply obliged.
Yeah, did production.
Thirty-five.
It's all right.
The double that fix.
No, we did production.
Production is item number 1.
Wait, please.
Manoj, on last Monday, this application was moved.
Diary was called for, right?
Yes, that was called. বাহিৰত বহি আছে। My lord, by the time they come, they filed a bail objection, my lord. If your lordship would kindly come to para 23 of that objection.
Para 23.
At page 65. This is the only paragraph against the petitioner in the entire affidavit.
It's probably on the way. You are appearing, ma'am?
In this case, I have already appeared on the last occasion,
Yeah.
but today it was not in the list.
No,
Oh, yeah.
mention the-
Production list. Yes. No, it was not in the list.
It is not in the list,
Not
so I am not.
production list. They mentioned last year. N. Chaudhary had appeared the last occasion. Yeah, she had appeared. The motion. Yes.
We need to file reply.
But they have filed it.
We have filed today.
File it.
We have filed. it.
Okay.
And we have mentioned it, we have informed them also that we will be mentioning.
Yes, but it is not in the list, so I.
It's
can-
not in the list.
So I.
No, my
can't
lord, it
take
was not in the list. That's why we informed them that we'll be making a mention.
Because
So
date
it-
was already fixed.
That was fixed today.
Yes.
No.
So they are aware of it, my lord.
Anyway.
Disputing that, what is it?
Oh, it was fixed today, but not listed. That's why it was mentioned.
So that's
Oh,
why we informed them
okay,
yesterday.
okay, don't worry about these things. So can I have it must be on the way. Is it there? Can I access the objection? Okay, or the objection?
Objection we have filed today.
Yes, but it's not come on the record.
It has not come in the board.
And then, my lord, will kindly take this matter tomorrow, my lord.
Tomorrow?
Yes.
As you wish. Tomorrow?
I don't know to say.
Tomorrow at 2, if you have,
2
if you
o'clock,
want some
yes.
flexibility, right? And the objection should come on record, right? Then we'll see. Yes. Motion.
Tomorrow, 2 o'clock.
CD is required, your lords.
M. Kumari. Yeah, CD will be required. Learned counsel, retainer counsel for CBI, M. Kumari, assisted by N. Chaudhary. And submits that. In the meantime, they have filed the objection, but it appears that it has not come into the record. This is the matter tomorrow. That is so and so at 2 p.m. Right? Showing the name of the learned retainer counsel CBI in the cost list.
Assisted by.
Assisted by N. Chaudhary. We'll look into it tomorrow.
Item number 35, fixed at 2 p.m.
though it was fixed at 2, I thought that probably it will take some time. Anyways, Lordship, this IA has been filed due to the fact that in the main bill application, in the name cost title, there has been an inadvertent typographical error, which is so requiring for correction in that particular line in the main bill application, name cost title,
Right.
in the petitioner number 2.
In our order, is it okay? There was an order. of
No,
this
no,
court.
that is why. In the order also, it is reflecting in the in the
Not in the body, but in
Yeah.
the cost title.
yes cost title. So that has to be
Yes, yes.
corrected. So
It's our
that-
mistake, then we have to correct it.
and also a little portion of the translated type copy of the FIR,
Mhm.
1 or 2 words.
Mhm.
There are some few
Mhm.
like mistranslated words. So
Yes.
we are
Mhm.
also incorporating the new corrected ones.
Maybe learned counsel for the, who's appearing? Anybody is appearing on the other side? There. Interlocutory application has been filed seeking to make some corrections in the cost title of the bail petition. And Annexure A, which is the translated and typed copy of the FIR. So these corrections only have to be made, right?
Yes.
These
On last
third
occasion.
line. I'll just cross check with you. Otherwise, he will write from here.
Yes.
This third line in cost title, he should be Sri Borun Majumdar,
Yes.
son of Borun Majumdar instead of wife of Borun Majumdar.
No. Lordship, it should be. It is currently it is now showing son of Sri Barun Majumdar.
Yeah.
It should be wife of Sri
Oh,
Bidgut Majumdar.
it should be wife of.
Yes. What are you doing?
It's okay. It's a lady, automatically that will be implied.
Yes,
actually.
but
Still. So, and next in the FIR.
Yes, FIR. And the
FIR?
translated type copy of the FIR.
Same.
No.
Same error.
No, there means we are going to completely amend the same this entire translated type copy. A few words are there.
Okay.
And
What
new
is
words are being
what is the correction in the type copy?
in the type copy, Lordship,
Instead of so and so.
is number 13. 1, 2, 3, 4, 5, 6. In the type copy in the 6th line. Lordship. 2, 3, 4, 5, 6. In the 6th line. Number 13 and actually.
In the
Sixth line. Sixth.
Okay.
It is showing November 1st, comma last year, but it is not last year.
Achha.
This is like 2025 this year. So last year had been mistakenly been incorporated on earlier occasion.
To
And-
page 13 of the
Page 13, 6th line, and then 6th, 7th, 8th, 9th, 10th, 11th, 12th, and then 12th.
That
In 12th, it is showing inform the principal of the institute about this, comma he. Actually, it should be she. It's not he. It's-
only that much.
Yes, it's on
That's
that's
all.
two words. Yes.
That's all. এইটো এনে কৰক আইৰ পেজ নাম্বাৰ 4 এইটো কৰি লওক এইটো wife of then in the title Annexure A page 13 of the main bail petition, the first correction লিখি লওক November 1st 2025.
Yes, it's 25. It is showing
this
last
this year.
This year.
Okay. This year. Instead of last year, it will be this year. My goal for this one. Or here, the principal of the institute, instead of he, it should be she.
Yes.
I did this. Page 13 and XI. Okay. Small little things, but
Earlier, it was
some trouble.
it could have been corrected on earlier directly, but now the procedure has been changed.
It goes into CIS.
Yes,
That is
yes,
why.
that is why. Lordship, now kindly fix the main benefit.
So this will dispose of the IA, right?
Yes,
With
ma'am.
these
Yes, it can.
corrections. These corrections are appear to be typographical errors and allowed to be corrected. The IA stands allowed and disposed of on the aforesaid terms. So how will you make the changes here?
No, we have to make it in the
Yes.
in the filing section, and it will come to registry.
Yes.
Now we just want to fix the main application on a short date, my lord. On 12/11, this was filed, and CD is also retained. It is already
It is also written.
Yeah. On any short date, like on 2nd, if it is possible.
No, they have some difficulty myself. You know,
Third?
third, fourth, I'll be on leave.
Oh.
And second, I am have some leave, so I'm not fixing many matters. Let us fix it on first or fifth. If you have urgency, we can fix it on Monday.
Oh, yes, we'll
Monday.
fix it
But
on
if
third.
you are, will you be able to do this exercise? Only 1 day is left. Otherwise, it will be before another bench. I have not heard this matter. No problem. Fix it on, let us fix it on second or third. Doesn't matter.
Yes.
I don't have to take it. I mean, someone, whatever the bench is, whoever takes that bench will take it. So, this after a week.
On second.
This has come, I say. In this, the case diary has been received in this case already and has been written pending the disposal, pending the interlocutory application, which has been disposed of today, full stop. List the matter, while retaining the case diary, list the matter on 1, should I fix it on 1 or 3?
3.
12. That will be comfortable.
Yes,
for you.
ma'am. The
Yes.
changes will be also highlighted.
Yes.
Obliged.
Again,
It doesn't. Submit bail hearing, it doesn't.
my lord, the petitioner before your lordship is in jail, my lord, since 24/8, my lord, today 94 days. my lord.
92 days.
And my lord, the case is registered under section, my lord, 22C, my lord. Yaba tablets are recovered, my lord. But my case is that, my lord, here, my lord, as per my instruction, my lord, he was not furnished, my lord, 47 notice, my lord. And he was arrested on the basis of statement, my lord, made by another arrested accused, my lord. So on these 2 grounds, my lord, I'm praying for bail, my lord. So, my lord, FIR at page 14, my lord. It is a long FIR, but I beg to show, my lord, the relevant portion of the FIR, my lord. Page 14, last paragraph, my lord. Last paragraph, my lord, after all preparation, my lord, on the basis of secret information, my lord, after intercepting, my lord, the suspected person, my lord,
Yes.
and my lord, they prepared, my lord,
I disclosed, how does it start? I disclosed my identity to him. It's like that?
and my lord, page 14, my lord, last paragraph. my lord.
Yes, I am on that one.
Yes, my lord. So, my lord, they
After
prepared
intercepting.
notice,
Hmm?
and my lord, witnesses were, my lord, prepared. Then, my lord, page 15, my lord, the accused was arrested. His name is, my lord, Shamim Ahmed Iqbal, my lord. From whom, my lord, these Yaba tablets were recovered, my lord. And this total, my lord, tablets, my lord, page 16, my lord. My lord, the third paragraph, my lord, therefore, from A and B, a total of 12,000 pink color tablets suspected to be Yaba tablets were recovered. The combined weight A and B, my lord, due to seizure list, my lord, recorded as 664 grams plus 705 grams, total 1 kilo 369 grams, my lord. My lord, now, my lord, my complication is, my lord, last part, my lord, subsequently, my lord. So, my lord, from
Page?
From, my lord, Shamim Ahmed Iqbal, my lord, this much Yaba tablets are recovered and they are connecting me, my lord, subsequently, my lord, in the same page, my lord, page 16, last part, my lord. How, my lord, this petitioner came to the
Similar issue again.
Here, my lord. Here, my lord, here, subsequently, the apprehended accused was further interrogated regarding his entire nexus during which he revealed that 3 individuals, namely, number 1, Tajuddin, I am not there, but I am number 2, Sultan Uddin, number 2, my lord, 37, son of so and so, a resident of Chandripur, Janiki Bajar, PS Algapur District, Hailakandi, Assam, number 3, my lord, so and so, a resident of so and so, Assam, had visited. This is, my lord, implicating part, my lord, had visited his residence from whom, my lord, Yaba tablet was recovered yesterday at around 12 noon and delivered the narcotic drugs contrabands to him for the purpose of selling in the Badorpur area, and accordingly they departed from his residence. They can, my lord, according to arrested accused, he further disclosed that the associates had called him and informed that they were on their way to from Panchgram side towards Badorpur. My lord, there are two, my lord, city type place, my lord, Panchgram and Badorpur. They are coming, so my lord, side in a car with the intention to jointly, my lord, jointly carrying out the contraband transaction in the Badorpur, my lord. So, my lord, here my allegation is that, my lord, this petitioner and two others yesterday went to this, my lord, arrested accused person, my lord, and gave them, my lord, this, my lord, contraband, my lord, and next day, my lord, they are also coming to Badorpur from Panchgram to help in selling the contraband materials, my lord. Our, my lord, submission before your lordship, my lord, this petitioner before your lordship, no way connected. Even he is claiming, my lord, he does not know this person, my lord. Background of the case is that, my lord,
Sultan.
yes, my lord. Background of this case, my lord, that, my lord, there was a Naka checking, my lord, and they are harassing, my lord, and their three friends are going to Badorpur for their personal works, my lord, and getting, my lord, sufficient disturb from this Naka checking, my lord. They are arguing along with the police, my lord, why they are, my lord, unnecessary harassing innocent person to find out one and two, my lord, the illegal person, my lord. Then, my lord, police take them, my lord, on grudge, my lord, being sentimental to the police station and made them, my lord, implicated in this case, my lord. This is their clear case, my lord. They are not at all, my lord. When police also tried to check out, my lord, the phone, bank accounts, etc., to get them involved in any case, my lord, but they failed to find out them involved, my lord, with any drugs peddlers, my lord, of this locality, my lord. Even then, my lord, he was sent to jail, my lord, and still then, my lord, he is in jail, my lord. Only basis of this alleged statement, my lord, but there is, according to the petitioner before your lordship, my lord, there are not such allegation even. That apart, my lord, as per my lord, copy received, my lord, he is not so much literate person, my lord, section, notice under section 47, also, my lord, according to him, not.
Can I see that?
Yes, my lord.
What's it?
That's it. 47. My learned friend is saying that, my lord, notice is there, my lord, but
Notice is there.
Notice is there.
Bilingual notice is there.
Very elaborate.
Bengali and
36, 47,
Anyway.
everything.
nowadays, my lord, they are punishing him.
48,
not,
I think 48. 47
instructed
also
me.
must be there.
Yes, yes.
Same
Proper 48 there, my lord. 48 I found, my lord. 35
Well,
copy, my
my
lord.
lord, it is in the CD, my lord. I have.
Nowadays, my lord, they are very, my lord, systematically notice, ready-made notice is given.
It should not be format, like standard format is there, but content should not be mechanical. You should do some.
Then, my lord, I have to, my lord, stick to my this, my lord, co-accused statement, my lord, in this regard, my lord, records, my lord, and I beg to, my lord, submit, my lord, two judgment, my lord.
Submit.
Kindly have a look, my lord, this two judgment.
In fact, my lord, in this case, I have seen, my lord, 47 notice is very elaborately given.
Yes, yes, yes.
Never seen such a detailed
Yes.
notice.
It carries to around 4 pages, 47 notice, my lord.
No,
Even
that's the earlier narration. He
Supreme
made
Court
it part of the
judgment is
notes.
also, my lord, mentioned. My lord, here, my lord, recent judgment of the Honorable Supreme Court, my lord. This is, my lord, 2022 live law, my lord, SC 622, my lord, Indira Banerjee. Sorry, my lord, it is parties. Name is, my lord, State of Haryana versus Samarth Kumar, my lord. May I read, my lord, this small paragraph, my lord. Here, my lord, paragraph 4, my lord. The High Court decided to grant pre-arrest bail, my lord.
Which one should I take up?
my lord, this my lord, state of Haryana versus my lord. Yes,
Samarthak Kumar. Oh. Yes.
just my lord, I am relying observation. Here, my lord, antecedent bail was granted, my lord, relying on the Tufan Singh, my lord. But Honorable Supreme Court held that, my lord, for regular bail, my lord, for final hearing, my lord, this Tufan Singh may be considered, my lord. Paragraph 1 of the High Court
State
decided.
had appealed against the grant of bail. State
Yes.
of Haryana had
Yes.
moved the Supreme Court.
Anticipatory bail they went,
Okay.
my lord. Paragraph 1 of the High Court decided to grant pre-arrest bail to the respondent on the only ground that no recovery was effected from the respondent and that they had been implicated only on the basis of disclosure statement of the main accused Danish Kumar. Therefore, reliance was placed by the High Court in the majority judgment of the court Tufan Singh versus so and so. Now, my lord, paragraph, my lord, 8, my lord. The next page, my lord. Here, my lord, Honorable Supreme Court observed that, my lord, in cases of this nature, the respondents may be able to take advantage of decision in the Tufan Singh versus State of Tamil Nadu Supra, perhaps at the time of arguing the regular bail application or at the time of final hearing after conclusion of the trial. So, my lord, Tufan Singh, my lord, principle.
That is actually, yes, this is what appeals to me also. Because at this time, that's at the time of arguing
Yes.
regular bail. Actually, it is most relevant after completion of investigation.
Yes, sir. But
When you have the
Yes,
complete
that is what
picture. Otherwise, investigation is an emerging situation.
emerging situation.
Actually, my lord,
That is why I am relying on
actually, my lord, this principle is very old principle.
But you have a discretion.
Yes.
But I'm not saying that you cannot.
Yes,
You
yes,
can
yes.
exercise a discretion.
Lordships,
Mandate is different.
mandate.
Exercise discretion is different.
Yes, different.
And of course, discretion should be exercised wisely.
My,
That is what.
my humble submission is that, my lord.
And this judgment, High
Yes,
Court.
yeah, is this judgment, my lord,
Sorry, your submission, you were saying something?
my submission is that, my lord, this principle is long back. The first judgment came from the Supreme Court in the year 1964, my lord. Only, my lord, in the Tufan Singh, my lord, this principle was reiterated that, my lord, this principle will also be considered in the, my lord, NDPS Act, my lord. Otherwise, my lord, it is long back, my lord, this law is settled, my lord, only on the basis of co-accused, my lord, without any other corroborative evidence should not be held guilty, my lord. This is a long, my lord, principle of law, my lord. This is only also applied in the Tufan Singh. Section, my lord, 67, my lord, statement is also like police statement, my lord. Therefore, that should not be, my lord, basis of conviction. This is held valid in the Tufan Singh. Now, my lord, paragraph 3, my lord, of this order, bail order, my lord, bail application 3887, my lord, 2023. Order dated, my lord, 1.
Our court.
Yes, my lord. Onil
Para 3, I should go to.
Yes, my lord. Para 3, my lord. Paragraph 3. Here, my lord, submission of the learned advocate of that case, my lord, learned Mr. So-and-so, counsel arguing for grant of bail, submits that in view of the determination made by the Honorable Apex Court in the case of State versus Hula bin Ahmed, so-and-so reported in so-and-so and a ratio laid down in the so-and-so to one thing again came regarding bail of confessional statement recorded under section 67 of NDPS Act. Such statement shall remain inadmissible even at the stage consideration of bail. Therefore, in the view of such settled position of law, the petitioner is entitled for grant of bail. Now, my lord, findings of observation of the court is, my lord, paragraph 14, my lord. Paragraph 14, my lord. That being the, may I read, my lord? That being the position and in view of the ratio laid down in the case of so-and-so, that a confessional statement recorded under section 67 of the NDPS Act 1984 will remain inadmissible in the trial of an offense under the NDPS Act, and therefore such statement, more particularly on the basis of confessional statement, voluntary statement of the co-accused, cannot be a ground to have a reasonable belief that the accused is guilty of the offense. Accordingly, bail was granted. So my humble submission before your
Not
lordship is-
guilty means at this stage, the interpretation is not going to be guilty, not likely to be guilty. That is
My
all.
humble submission is that, my lord, he is a completely stranger, even no, my lord, social relation, no identity, not known person, my lord. Only, my lord, there is a quarrel, my lord, in the
So,
queue of the.
then let us see, since he has elaborated, now I just come to, can I
Yes,
come
my
to
lord.
him?
Yes, my lord.
So, since he has elaborated with Ayok, so
Yes.
let us first see the grounds of arrest. Let us see his grounds of arrest. Of this person, Sultan of the children. Your related brother.
And also kindly see the my lord,
Are running an illegal business. Oh, 47.
44.
No, that's okay. But again, we are back to the same question.
Same question.
Same
ma'am.
question.
Same
We are back to the
Same question, ma'am.
And this,
Now-
you know, this question will in commercial quantity cases of NDPS, this question will come up again and
Again
again.
and again.
Therefore, it will be very helpful and necessary. It will be essential in the coming days that this individual narration is made.
See the framework one severe analysis of the IO method. There some light has been shown on it now. But may kindly.
So here,
Yes, we can note madam. The CTR have flag mark.
Nowadays, my lord,
the course of investigation, it has been written that and so on and provide static was. Who were caught at the with the tablets? Who?
Co-accused, my lord, I have just your lordship may kindly see the co-accused statement. I have.
No. The names of the persons who were
Oh,
caught.
yeah, he is,
I
my
have-
lord,
I have flag mark.
Shamim Ahmed Iqbal, my lord.
I am given the,
Only one.
Yes, my lord.
I have given his statement, lordship may kindly peruse, it is there.
So no, that is there, but if that cannot be taken into account. Shami Mohammed Iqbal.
Yes, analysis manner has to be related with the statement what the made by the person from whom it is. And there is also his own confessional statement, manner, though it is not under section 27. This is a stage of pre-search statement.
Accordingly, after completion of all the proceeding. 10% mistake. Okay. Investigation. No.
Yes, now, if your lordship permits me, my lord.
Yeah.
Just rely on your lordship's one order, my lord, that is been cited in the previous case, my lord, regarding what your lordship has, my lord, observed regarding at stage of the, my lord, when it is a pre-stage of the search sheet, my lord. That is.
This one, Supreme Court doesn't.
That is, your lordship has delivered on, my lord, BA 2070/25, my lord. Just I'm reading what lordship's, my lord, perhaps may throw some light.
BA?
However, if the investigation, however, if the investigation.
I
is
have
not-
my own order.
Yes, yes.
I
my
feel
lord. Yes,
embarrassed.
because this is the, your lordship, perhaps it is a.
I have
perfect-
limited knowledge.
Perfect interpretation of the matter, because so far the other Supreme Court law is concerned, my lord. That it is not completed, if the investigation is not yet completed and the investigation authorities are still collecting evidence as part process of investigation, then perhaps it would be somewhat premature to hold that accused is not guilty of the alleged offences pertaining to commercial quantity, despite the fact that till that stage, the only incriminating materials might be the confession of co-accused under section 67 of NDPS Act. Such an approach would be more necessary, in my considered view, if the bail question is an anticipatory bail rather than a regular bail for releasing the accused in custody. On the basis of such material, if the accused is released on bail, even while the investigation remains in progress, that would, in my considered view, amount in a way to prejudice the question of prima facie guilt and might constitute some prejudice to the investigating authority and the prosecution matter. One paragraph I have done. In that case, your lordship has rejected the bail because the investigation is completed. And regarding statutory 37, my lord, in any case, section 37 imposes a statutory bar on granting bail if the court is unable to come to a finding on the basis of materials that the accused is not guilty. If the court arrives at such a finding in favor of the prosecution, the court is obviously barred from granting bail. Even if the court does not arrive at such a finding, the other restriction on grant of bail would still apply as provided by section 37 of the NDPS Act itself. Thus, in a situation, only the statement of the court might be better placed to hold that accused is not guilty within. That is, yes, because your lordship is dealing with the stage manner when it is before a start stage manner. And
True, true.
that is going to the investigation, and the lordship has perused that CD, my lord, I have placed before your record, my lord. And there are also judgments that says, my lord, I just read in an earlier occasion, my lord, the 67 cannot be ignored totally at the time of investigation, because your lordship has a prima facie, your lordship has to make a satisfaction under section 37. That would be perhaps should be sufficient from the CD, my lord, at the time of investigation. The conviction part is, my lord, different, my lord. Charge part is different. What so far my limited understanding, my lord.
Yes, yes. No, no. Right. I would have been happy if this was taken up because sometimes then only, it needs to be cross-checked whether
You know,
this viewpoint is correct.
because-
One can always be wrong.
Yes, no, in this.
We are
in
learning
this
all the
line-
time.
In this line, there is a Supreme Court judgment is also there in this line. Section 67 vis-a-vis the Tufan Singh matter. I can place it tomorrow, madam.
I think I'll dispose it of.
Well, yes.
Since CD is also here, you take a seat. Okay. What are the heard AM Borgum, Learned Council, additional PP, 483 bail application for the accused petitioner Sultan Uddin Chaudhary in connection, who was arrested on 24/8/25 in connection with Badarpur PS case number 153 of 25 under section 22C29 of the NDPS. Let's stop. The case arose out of an FIR dated. Case was registered pursuant to an FIR dated 24/8/2025. Whereupon an information was received in the Badarpur PS about one person, Samir Muhammad Iqbal, moving in that area with narcotic drugs for the purpose of selling. Full stop. that, on the basis of the information, the said person was intercepted, and upon his search, police found 12,000 numbers of Yaba tablets. Full stop. That subsequently, upon his interrogation at the police station, the names of 3 other persons were revealed, including the present petitioner. Full stop. And that they had delivered narcotic drugs to the arrested person for the purpose of selling in the Badarpur area. Full stop. Information was also received that these persons are coming in a vehicle towards Badarpur with a vehicle. Full stop. It was also revealed that the car had registration number AH01AN 3396. That that a Naka was laid, and the said vehicle was intercepted, and all the 3 occupants therein, including the present petitioner, were arrested. The Mr. Bordmiya, learned counsel for the petitioner, submits that the petitioner has been falsely implicated, and that he has been arrested solely on the basis of statement of the initially arrested accused Sami Muhammad Iqbal, and referring to the principle laid down in the case of Tufan Singh, the learned counsel submits that the same may not be taken as sufficient to deny bail to the accused. Stop. Learned counsel has also referred to the case of State of Haryana versus Samarth Kumar, 2022 Live Law SC 622. Para 4 and Para 8 thereof may be reproduced here in below. The learned counsel has also relied upon decision of this court rendered in Anil Malakar versus State, being BA 3887 of 23, and drawn attention to Para 3, which may be reproduced here in the text. The case diary as called for has been received and relevant portions perused. I have also perused the arrest memo and the notices under 4748 BNSS and found them to be meeting the requisite standards. Full stop. The learned additional PP submits that huge quantity of contraband has been seized in the instant case, clearly falling in the bracket of commercial quantity, and that investigation is going on. It is submitted that there are sufficient materials against the present petitioner as well, and therefore he cannot get the benefit of the aforesaid decision, benefit of the principles which follow from the aforesaid from the decisions cited at the bar by the learned counsel for the petition. It is submitted that there are incriminating CDR analysis materials, and which implicate the present petitioner as well, and that there are materials which go beyond merely the incriminating statements of co-accused. I have carefully perused the relevant portions of the case diary pointed out by the learned prosecution. Stop. It is stated that the CDRs were analyzed with regard to the information that the three persons who were arrested in the vehicle, including the present petitioner, coordinated with the initially arrested accused regarding initially arrested accused Samim Iqbal with regard to transaction of narcotics in that Badarpur area. And it was found that the CDR analysis and it was found that there were several contacts. There were numerous contacts between them at the relevant time, and that they were also their location was also found in that area. Also, from the materials of the case diary, I find that information was received about the three persons, including the present petitioner, coming in a vehicle. And on the basis of the information, the three persons, including the petitioner, were actually found coming in the car, and they were also apprehended. So I have given my consideration to the matter at hand and the relevant materials. Needless to say that Tufan Singh Supra settled the principle that a conviction in an NDPS case cannot be recorded solely on the basis of the statement of the co-accused. As regards the question of bail, vis-a-vis, regarding the question of bail, the governing law at the moment does not say, in my considered view, that the only materials against the accused is a statement of co-accused. He has to be granted. He has to be mandatorily granted bail. Stop. However, it cannot be denied that the said aspect of the matter can definitely be taken into account for exercising wise judicial discretion while adjudicating a bail. Stop. Moreover, the court would be in a better position to ascertain that aspect within bracket likhwa. The only material being the statement of co-accused. After a complete picture is before the court upon completion of investigation. As investigation is an emerging situation. Therefore, for completion of investigation, it may be in some ways when premature to hold vis-a-vis section 37 of the NDPS Act that the petitioner is not guilty, merely because the materials that far would be only in the nature of statement of co-accused. Next panel. In the instant case, I find that investigation has revealed significant incriminating materials against the initially arrested accused, significant incriminating materials. So investigation is an active progress. In the instant case, I am of the considered view that even leaving aside the incriminating statements of co-accused, there are other materials which are adverse to the present petitioner seeking bail. In the entire facts and circumstances, and in the backdrop of the above discussion, I am of the considered view that it may not be prudent from the point of view of effective investigation to grant bail to the accused petitioner at this stage. Stop. I also do not find any fatal procedural infirmity violative of any constitutional rights to entitling the petitioner to be granted bail. Consequently, the instant bail petition stands rejected at this stage. Return back the case to short order.
Obliging.
Break it like right. Break. Break.
May I please, your lordship?
Yes, yes.
My lord, FIR at page 8, your lordship.
Yeah, Paris, my lord, search sheet laid down, my lord.
6 of POXO Act.
Yes,
My lord.
search sheet, laid, my lord.
But in the FIR itself, there is no elements of.
Yes, you want me to see the FIR? Yeah,
My lord,
please.
at page 8, your lordship.
8.
8.
Yeah, he's on interim.
Type copy.
He's on interim.
He already on interim, my lord.
No,
But
madam.
now, sir.
No, no.
It's
No.
fine.
Must be another case.
Nine.
Here, regular bed.
Compulsory. Fully.
9.
Because there is a noting that he is on outside. But
My lord, in the FIR.
Absolutely. Yes, please.
4 persons are named.
Yes, yes.
And I am not named in the FIR, your lordship.
Mhm.
And all these 4 persons have been granted bail, your lordship. And this present accused petitioner is in jail for about 78 days, your lordship. And so
Okay.
what allegation is concerned, my lord,
Mhm.
allegation attracts section 8, your lordship,
Mhm.
but registered under section 6, your lord. And at any conditions.
You are not named in the FIR also,
Yes, my lord,
but
not named. I am Anisur.
charge sheet is there.
search sheet laid down.
Is it there?
My lord, no, it is not there, but we have received a message, my lord, that the search
He has
sheet-
been sent up.
That is not.
That you
clear.
cannot say.
Yes.
I will cooperate.
Can we see one of the bail order?
My lord.
Why so many persons, male
Yes, page 7.
persons given in a POXO case? I mean,
My lord. Page 17, your lordship.
My lord, there is a procedure, my lord, regarding service, my lord, because
Oh, yeah, that we'll see. That will.
Your lordship will see the nature of allegation, your lordship.
One of the bail order, let me see.
Lordship.
Page 17, your lordship. Lower court has granted bail
Now,
to all the FIR name accused, your lordship. Page 17, bottom,
statutory bail, actually.
my lord. Statutory. But rejected the in the
No,
court
no,
of the present petitioner.
investigation complete, but charge sheet had not come into the record. So it was, he was.
Only on the ground that short period of detention, the bail petition was rejected in respect of this present petitioner, your lordship.
It's the default bill, right? Default bill, right?
Reject for the.
Is it?
I opened the trial, your lordship. At any conditions.
No, this is a rejection order. Any order of granting bail.
Granting bail, page 17, your lordship.
No, sir, it's a.
Bottom.
Hmm?
Last paragraph.
Persons are allowed to bail. Oh, they were, oh, I can see. One merit bail was rejected. They were allowed to go on default bail. actually.
My-
Default bail. He's in custody since
11/9, your lordship.
11/9.
11/9. Arrested on 9/9, forwarded on 11/9. your lordship.
We need a copy of the charge sheet to see, you know, because we don't know what material is there. He's not named in FIR, and the others, 3 have got anticipated this default bail. Minor girl, child welfare committee, this is one side of heart.
Your lordship.
Then abused, physically and sexually abused.
Only court accused is. In fact, my lord, this present petitioner being a day laborer, 2 years back, he went to the district of Dibrugarh for doing labor works, and he worked there for about 30 days. 2 years back, your lordship. I have categorically stated at para number 6, your lordship.
We'll have to-
Page
Page 4, para number 6, may kindly be considering.
Page?
Page 4, para number 6. This is the real fact, Lokas. He does not know the victim. Only because of that, he is known to the other co-accused, my lord, affair name accused. He has been arrested from the district of Dhubari. My lord, kindly bail may be granted.
Because I do not have any materials.
But
I'm also
page 15, my lord, they throw some light, my lord. In the forwarding, my lord. Next to. Lordship, may kindly come to grounds of arrest, point number 4. As per victim statement, my lord, that has been recorded.
But in what backdrop? All of them are male persons.
Yes.
And they were staying together or we don't know anything.
Recorded her
So let us get
Paragraph
the
164, he has.
164 is there?
No, my, that is what is, but Lordship, may kindly come to page, point number 4, my lord.
Yes, I have seen.
Page 15.
Victim statement.
As per victim statement,
Recorded
recorded under judicial statement, my
Like arrested accused persons.
sexually and physically abused.
No, this is with regard to Anisur Haq.
Anisur Haq.
Anisur Haq.
Yes.
Anisur Haq. But
This is Anisur Haq.
it's Anisur Haq.
Yes.
We don't know actually. So let us, we do not have some sufficient materials actually to dispose of this material. So give me some time to get the, and process also has to be completed, I think.
I will call
The steps have been taken.
my lord.
Steps have been taken. Service, it's awaited.
Yes.
I will face the trial, my lord.
Wait,
I will face the trial.
If there are no, theoretically speaking, if there are no sufficient materials,
My-
you should not even face trial. If there, you
Yes,
have to
yes,
see
yes.
why he has been
Yes, yes.
arrested, why he has been sent up for
Yes.
trial, isn't it?
Yes.
So, can you take instructions? The heard
Whether he has
counsel
been sent for trial or
so-
that part, my
and no, we'll need the charge sheet.
search sheet copy.
Charge.
Lordship.
Or would you like to seek bail in the court below?
Court below, that is rejected, my lord.
No, after this.
Because of completion of investigation. No, so
Some direction may be given.
it was known.
And to
It was,
consider the.
it was rejected. Yes.
My lord.
And he can, after now, my lord, it is a fresh case because after search sheet, he can approve.
And that's true.
But he will face, he will languish in here, my lord. For his benefit, my lord.
If possible, my lord, at any condition, my lord.
No, because see,
By imposing any condition, your lordship.
his bail was, yes, his bail was, when his bail was disposed of, charge sheet had been submitted. Charge sheet had been submitted.
Letter.
Because it has, they have mentioned completed statutory period. Investigation has been completed, but IO has not submitted the charge sheet. Charge sheet does not come into the record.
Yes, yes.
That is how it has been. You can try again. Would you try in the trial court? But see, no court can give actually that direction that you grant bail. You know? That is why, you know, we exercise sovereign, it's called sovereign power. Nobody can give.
As far
Judicial magistrate, nobody, and direction to consider is actually not necessary, but though we give. But whether to give or not, nobody can give.
trial court will decide as per law, he can. approve.
If you desire that, I can say, I can
My lord.
direct that.
My lord.
Should I? You take a chance. If you
My-
get rejected, come here again. In the meantime, then by the time we'll,
Some positive direction may be given.
The present petitioner invoking 483 BNSS is seeking regular bail in connection with Naharkotia PS case number 39 of 25 under so and so. He was arrested on 11/9/2025. The FIR stated 17/7/25 lost by District Child Protection Officer Dibrugarh with the allegation that the FIR named persons had physically and sexually abused the victim stated to be aged 15 years. It's true. The present petitioner was not named in the FIR, but he was arrested during investigation. It's true. The case is his bail petition before the learned court below was rejected on 16/10/2025. The charge sheet, the case is stated to have been charge sheeted, but no further details are available. In the given situation, this bail petition is disposed of with the direction that the petitioner may approach the learned trial court for regular bail, and upon doing so, the same shall be considered and disposed of, needless to say, in accordance with law, and also keeping in mind the stage of the case. Stage of the case.
All FIR accused have been granted.
And
FIR.
that we should not do indirectly, actually. So aspect of, and also because that will almost indicate that I'm telling the grant bail. So last word too. Stage of the case. And any similar situation with regard to co-accused. Court also doesn't like, actually, because that is why this institution is special, because you are independent.
Yeah.
In your work, you're fully independent. Yes, please.
May I please, Lordship, I've already taken a statement on last occasion also.
Yeah.
As for official service does not yet to be completed, my lord. My lord, petitioner, my lord.
Abhayapuri.
Jail, yes, my lord. Already, as per instructions, my lord, the case has been, my lord, already a special case number has been registered, my lord.
Yes, sir.
That is, my lord, pending before the learned special judge, my lord, at North Shalmar at Abhayapuri, my lord. There is a special case number 99/2025, my lord. That is fixed on, my lord, on 5/12.
Okay. Diary is not received.
No.
So this report also same.
As per the
Justice
special case, yes, my lord. Case is pending, my lord, in
Oh, yeah.
learned special judge, my lord.
So
At North Shalmar, Abhayapuri.
would you approach the trial court?
My lord, already approached, my lord, but that is, I have annexed that order, my lord.
Rejected.
Yes, my lord. That is page 17, my lord. Page 17.
So I've got it.
At this stage, my lord, trial court record, my lord.
Yeah, we can call for that, should we?
Yes. And I may be allowed to, my lord, take a fresh step if possible. Fresh step, I may be allowed to take fresh step, my lord.
Okay.
Pro learned PP.
Yes, you can take first steps. The case diary not received. The case diary is not received. The learned counsel, the petitioner submits that as per his information, the case has been charged sheeted, resulting in registration of special POCSO case number 99/2025 pending before the learned special judge North Salmara Abhayapuri. Footstep. He undertakes to take fresh steps upon the informant. R2. The prayer is allowed. Steps may be taken through PP, Office of PP
My lord, for registry, it will come thereafter, it will come to.
Yes.
PCO, my lord.
To be executed by the concerned police station. In the meantime, call for the scan copy of case diary and charge sheet. Scan. Yeah, but main thing is that we don't need necessary order sheet. Main thing is the case diary and
My lord, yes.
case diary and charge sheet. Okay, scan case report comprising case diary and charge sheet. And any other relevant documents. Please the matter on. We can,
The last part of December, my lord.
last part of December is
It's
closed.
too long, my lord. Otherwise, he's in jail for long days, my lord.
Poxo 4 is there, my lord.
Any,
She-
my lord,
Is a lady.
already is no, my lord. They say
Main person, the accused.
20th of August, my lord.
Yes, I've seen.
He's in jail, my lord, 20th of August, my lord.
Is it? Take it to the,
16th, my lord.
or maybe,
12, my lord, it was.
no, I have no problem, but 12, 13,
12, my lord.
12. Because I don't know how many
Obliged,
letters
my
will be listed that day.
16.
Much obliged.
May it please your lordship.
Mhm.
The regular bail application, your lordship. The FIR is at page number 9.
Mhm.
The main contents is page number 10, your lordship.
Mhm.
27A of the NDPS is there, along with small quantity, your lord.
Oh, contest.
Page number 10, your lord.
21B they have given. Page 10,
Page number 10, your lordship, the operative
Mhm.
part of the FIR, your lord.
operative part.
May I read the FIR?
Yes, please.
We left from PS using departmental Bolero vehicle bearing registration number so, driven by driver HG Midul Bora and proceeded towards Difu bypass. On reaching at the place of occurrence, we found that persons, namely 1 Manas Sorgeri, 2 Victor Ekka, and 3 Amrit Tirki, along with 1 vehicle bearing registration number so, and apprehended them. Accordingly, I asked the apprehended drug peddlers whether I wanted to search their body in presence of the witnesses, but then I went to search of their body by me and they had no objection. Therefore, I provided him with under notice 50 of the NDPS Act. With the permission, I searched the body of the persons in front of the local independent witnesses, namely so and so. During the body search of the apprehended suspected drugs peddler, NDPS article was found from the vehicle, but I recovered total 4 numbers of plastic container containing suspected to be heroin during search of the vehicle. After that, I weighted the recovery suspected to be heroin with the help of PS weighing machine in presence of the above mentioned local independent witnesses and found total weight 8.99 grams with container. As well as I have tested a small sample of recovery suspected to be heroin with PS NDPS test kit and found positive results. Accordingly, I seized the below mentioned articles from the possession of the drugs peddler, your lordship. 4 numbers of plastic container, 1 vehicle, 1 mobile handset. This is the case in total, your lordship. Furthermore, your lordship, when they were remanded and the seizure was brought before the magistrate, it came out to be 4.91 grams without the container, your lordship, which is small quantity of the NDPS Act, your lordship. Furthermore, only section 27A has been mechanically arrested, whereas in the same affair, they are been stated as peddlers and not someone who is financing or harboring illicit drug trafficking, your lordships. Therefore, we are praying that 27A is not attracted to any of the accused person. The car has already been granted Zimma and the quantity is just 4.99 grams, your lordship. Already 43 days behind the bars. May we be allowed to go on bail, sir.
So, please. There is coming.
Here, FSL report, my lord. FSL report part with receipt, my lord. And regarding their involvement, my lord, and I was collected materials against them, my lord. All of the, my lord, it was recovered from their position, my lord. And investigation is going on, my lord. And the contravention was sent for FSL, my lord, it was not received.
What is the judgment, because of we had used it when I was in district Jorat, because the judgment of a short order of our High Court where it was held, that it was not actually, it was observed that it's bailable in case of small quantity. Do you have that order?
I do not have the
It's not a reported judgment actually, because there is a very elaborate, there's a very elaborate long order, you must be aware, of Bombay High Court in Riya Chakravarti's case, where they are referring to this Baldev Singh constitutional bench. They have clearly stated that all offences under NDPS are non-bailable. You know,
That is acceptable because
but that is Bombay High Court
the
persuasive
NDPS
value. But
and-
here we are, because if you, why I'm raising this point is that 27 materials we have to see. If there are no 27 materials, then the other one giving of the section is not final.
Indeed.
If it is the sampling is, that is the authoritative, the magistrate samples. If it is small quantity, then it will be, then it has to be given
The order of the
bail.
district.
Below 5 grams, heroin would be small quantity. Even below 5 grams would be small quantity in case of heroin. Where is that inventory document? Or it would be in the charge sheet, it would be in the case diary. It would be in the city.
I have a copy of the same.
But that order, that brief order of our court, that has not been disturbed by any larger bench. So we'll follow that.
Judicial magistrate order, Your Lordship.
We'll follow that. No, this is Sam. No? Bitcoin. Container has to be excluded because it's not neutral substance. That is not neutral. 4.91. So this will be below 5. It's a small quantity. Small quantity.
Moreover, Your Lordship, with regards to the judgment, which talks about a small quantity being available, may I please take assistance from Surplus, sir, regarding the same, Your Lordship.
We'll also find it. If you,
Judgment by
it's not reported.
Honorable Justice Mridul Kurita on Bilal Hussain versus State of Assam,
No.
where all of those issues have been discussed, including Baldev Singh and my lord, the Bombay High Court judgments, and a definite finding has been given by the coordinate bench.
That is subsequent. The first order was of Justice
Justice Michael Mann.
Thereafter, this one.
This one. That was an Amir Ali was a very short order, but Justice Kurita.
Whatever it is, but we were following that in the district.
Yes. Justice
So
Kurita.
this is the elaborate order.
Elaborate order.
So
That aspect of whether it is bailable and non-bailable,
that has been discussed.
That has been discussed.
Is it reported?
It is reported. I have a copy.
It should be reported actually. We can also
I'll give
convey
a
to
copy,
them.
my lord.
Yes. I'll have, what is the name?
Bilal Hussain versus State of.
I'll find out. Now we are, we'll go by that since, unless Honorable Supreme Court speaks on the issue, but the Bombay High Court judgment is very elaborate.
Yes,
This Sushant Singh, that
Yes,
time,
yes.
that girl, actress.
Here that distinction
So,
has been drawn.
that
as to-
judgment.
Yes, distinction has been drawn as to why that judgment was par incuriam,
Hmm.
and the other judgments, Stephen Muller
Yeah,
and all other
very
judgments
good.
have been discussed.
Very learned judgment. Because, see, this is, I think that is the distinction. I think the Bombay High Court judgment, don't have time, okay, but you went into that aspect. That heading says all offences non-bailable, cognizable. But the inside, the
Punishment.
thing is not there. Punishment is
1 year
different.
punishment.
Different. So what will the heading will be determinative or something else will be?
But the case number is AB 3029 of 2024.
AB
3029 of 2024.
2024. Sibu, Raki, I think
Moreover, Your Lordship.
we'll
with
get it
regards-
reported also.
With regards to 27A, Your Lordship also has reiterated a lot number of times that not just source information, but some other material must be available to connect 27A so that it can be shown that we are harboring or financing illicit drug trafficking, Your Lordship. To that aspect, we are completely innocent and there is no materials also available against us.
Because financing drug trafficking
It's a big offense.
is a serious
It's
offense,
a big-
obviously.
At this stage, our bail petition will be considered, Your Lordship.
So-
The age is 21 years and 26 years, Your Lordship.
What are the materials? That is why 27 determination is important in this matter, because the remaining part becomes available, right? And if 27 comes, forget non-bailable, 37.
37 will come.
Could you find any materials with regard to financing
But investigation is going on, madam. In the IO.
so far?
Madam, in the objection of the IO, madam, it is mentioned that they are also involved in such type of offences, madam.
me have a look. I have not come across any judgment, by Apex Court explaining the scope of 27A. If you find, you can,
Lordship, with
you
regard to
can-
the interpretation
we
part,
can discuss sometimes.
it would be someone who is not present at the place of occurrence. Your Lordship. That would attract 27A. Here, the police themselves said that we are a peddler, Your Lordship, and not someone who is financing. And moreover, Your Lordship may consider the age of the petitioners, Your Lordship, 21 years, 26 years, and 27 years.
Not necessary, my lord. Age is not the, my lord, consideration.
There
by the-
might be
Here,
drug
they are
addicts also
involved in such type of heinous offenses, my
in
lord.
need of rehabilitation also, Your Lordship.
Age is not the consideration, my lord. 27 years, 26 years, my lord.
And for 27A, Your Lordship, some standalone material, Your Lordship.
We have to be clear about, even case laws would be of help, but common sense and logically, we have to be clear about what financing, I give you money.
My lord,
Then
my
you buy 10 kgs of ganja from Ujan
Right.
Bazaar and sell it in
lord,
Ganeshpur.
everything.
That will be finance. I'm not taking drugs also, suppose. That will be financing.
Right.
That will be financing, right? So there is no materials then so far.
The food of combination is 8.9, without 4.9.
That's all. No problem. We have the last line counsel for the petitioner, additional public prosecutor. Okay. 483 bail application for seeking bail for. This for several petitioners.
3 petitioners.
Victor Ekka, Manav Soren, who were arrested on 15/10/2025 in connection with Doboka PS case number 202 of 2025. Registered under section 21B 27/29 of the NDPS Act. So the gist of the allegations in the FIR dated 14/10/2025 is that upon an information, search operation was conducted at the place of occurrence and apprehended three accused persons hearing, although all of them are here. And from the vehicle AS01 FB 5261, suspected contraband in the nature of heroin, along with some other materials, were seized. The quantity of heroin was stated to be 8.999 grams. However, after the sampling procedure, the said quantity is stated to be 4.91 grams without the content. With regard to heroin, quantity below 5 grams would fall in the bracket of small quantity stuff. In terms of section 37 NDPS Act, the rigors thereof would be applicable with regard to with regard to the penal provision of section 27A of the Act as well. Full stop. The said penal provision criminalizes the act of financing drug trafficking, financing drug trafficking. Full stop. Harboring. The case diary as called for has been received. Heard on it. Additional public prosecutor. Stop. Upon it is submitted by the learned additional PP that upon perusing the case there, he has just correct me if you have any. He has not noticed. He has not yet noticed any materials directly with regard to financing of drug trafficking. However, there are incriminating materials against the petitioners and indicative of their being indulging in peddling as well. And the investigation is still in progress. Therefore, in this context, the prosecution opposes the bail. Though Section 27A of the NDPS Act attracts the rigors of Section 37, but but quantity of contraband in the bracket of small quantity would make them would make the offense bailable as per the principles as per the law laid down by this court in the case of Bilal Hussain versus State AB number 3029/2024. It appears that there is no authoritative pronouncement of the Honorable Apex Court as yet on the question as to whether quantities falling in the bracket of offenses pertaining to small quantity under the NDPS Act would be available or non-available. Next one. In terms of the settled law with regard to Section 30, I'll just write a brief paragraph on a few lines. In terms of the settled law with regard to Section 37 of the NDPS Act, if the court is unable to hold on the basis of the materials that the accused is not guilty prima facie, then the statutory bar would be applicable. On granting of bail. Such a bar would be applicable even to constitutional court like the High Court, and perhaps might give way at a subsequent stage to the principles of Article 21 of the Constitution of India. Full stop. Especially if there is undue delay in the completion of the trial. Stop. Thus, where the rigors of Section 37 NDPS Act are applicable per se, the court is statutorily prohibited from granting bail. Full stop. However, even where the rigors, even where the test of Section 37 of the NDPS Act is passed in favor of the accused, the general restrictions or parameters governing adjudication of bail would still be applicable, and in a particular situation, the court will still have the discretion to refuse bail. Full stop. Next paragraph. However, in the instant case, if there are no materials at this stage with regard to Section 27A, the remaining provision, though the remaining penal provision is Section 21B, but in view of the determination by the magistrate and finding the quantity to be in the bracket of small quantity. Therefore, the petitioners would be entitled to be given bail as these as offences pertaining to small quantity are bailable within the jurisdiction of this court. Accordingly, in the given facts and circumstances, and in view of the above discussion, all three, right?
All
three accused petitioners allowed to go on bail of rupees 25,000 each, surety of the like amount each, to the satisfaction of the concerned court, which will be special judge.
Special judge Hojai.
Ho jai, yes. And subject to the condition number 1, they shall cooperate with remaining investigation. Number 2, they shall not hamper on separate evidence. They shall not misuse their liberty to indulge in any activities, any illegal activities, including any activities violative of the NDPS Act.
And deeply.
Violation will entail cancellation of the bail.
Much appreciated.
Return back this there. Left behind so many matters. What to do? We'll do one more matter. And we can maintain.
17, my.
Then we can do that. You can do that.
Yes.
17.
Well, look here, the petitioner, he was arrested on.
Just a
In this case, with all respect,
I have mentioned not noticed. That's okay, no? Earlier matter. No, 27A, that matter. I have used the expression not noticed. Prosecution. That's okay, no? That's okay. So, I have to see your interest also.
Investigation is going on.
No issues. He has not noticed. That's what I have written, actually. You're not noticed. Yeah, so it's better to say that rather than absolute, that not there.
Well, here,
Don't worry.
only
Yes.
for effect is, my lord, the petitioner, he was arrested on 12/3/2025.
Okay.
On 10:45 AM. And he was produced before the court on 13/3/2025 at 2 PM or thereafter. So why he kept in this police station, and there is no explanation, my lord. Now, second, my lord, although it is mentioned in the forwarding report that notice under section 47, 48, 43 has been served, but no notice has been served to the family members. They are not received any such notice, my lord. Number 3, my lord, in the FIR, you shall kindly see.
Yes, trial started.
The trial started.
Okay.
At several death has been given. The no
Evidence.
witness has come, my lord.
No.
This is for the time.
Prosecution examined.
No one
started.
No one is. They started, but they are not come forward. And in the 260 days, I am in jail. 260 days. Now you also kindly see, they say that 20 kg, 750 grams ganja has been seized in 4 plastic packets, including, my lord. That 4 packets weight has not been minus. If it is minus, it will be come to a value commercial quantity, my lord. You will also kindly see the forwarding report and it will FIR, my lord. Page 13 is the FIR. Down below, my lord, bottom, my lord. SARS found 4 nongs of packets wrapped with black color. Now, page 14 it is clearly mentioned. 4 nongs of plastic packets wrapped with black color plastic filled with suspected ganja. 20.74 kg. So, the weight of the 4 plastic has not been detected.
Sampling, you should see.
Yes.
Sampling.
Now, my
The
lord.
duty of the magistrate to certify the quantity, right?
Now, my lord, if forwarding report, my lord, they mentioned that notice under sections 47, 48, and under section 43 and device has been served. But no notice has been served to the 48 notice has been served to the family members, friends to of the petitioner of my lord. He was arrested from the railway tracks. After getting some information, this is the main facts, my lord. Now let's kindly see the witnesses. There are several witnesses, my lord. A long time is to be required. Nine witnesses here.
Nine witnesses.
Yes. So, my lord,
260 days I am in
This
jail.
notice is there, it's not.
My
there.
lord.
Notice is not here.
Yes, yes, scan copy is called for.
Scan
Scan
copy
copy
call
come,
for,
my lord.
but I have, I'm sorry, well, I have to see the scan copy.
Only my lord, notice is there. They say notice has been served, but no notice has been received by the family member till today, my lord.
And
You're
regarding the
also
weight,
very busy.
weight also, if my lord plastic, along with plastic packet, it is 20.7.
20. If 4 packets is detected, it
Yes.
should become
Weight of
under
the,
below.
weight of the 4 packets have to be seen, my lord, then.
Yes.
There was already gone through one judgment by earlier placed before lordships in Himachal versus judgment. Himachal protest.
There is no dispute, my lord. Only the packets has to be deducted. my lord.
Yes.
Now suppose it is commercial, above commercial, then also 260 days I mean jail has got, my lord. And no one has been
No, no,
examined
actually,
till today.
37,
Yes.
37 is you have to fully understand the
Yes.
37. It's a very, very
Yes.
tough test.
My lord.
Tougher than the 43D
Yes, yes.
test of UAPA.
Yes.
There it is prima facie true. Allegations are prima facie true. Here it is reasonable grounds to hold that he is not guilty.
On the for the length of detention, my lord, and the lordship may consider the bail of the petitioners, my lord.
This judgment is that argument.
Yes, I also only country. And Bihan Kumar also
Parts of-
regarding notice, my lord. Notice.
Where can I find it? Can I
Yes,
find all the
it
materials?
is Bihan Kumar, my lord.
Sure.
But question is, no notice served, my lord. 480, 48 notice is to be served to the family members or his friends. But no such notice has been served. Bihan Kumar's, my lord. Yes. It is conclusion part, my lord. It is clearly laid on the
21,
guidelines. my
para
lord.
21.
Yes, para 21, my lord. Laid on the guidelines, my lord. So, on that ground, petition is entitled to get bail, my lord.
Settled.
There is no dispute, my lord.
Yes, it's not this.
Take a record.
260 days I am jail, my lord. More than 8 months.
Is there any magistrate certificate regarding
No,
the
nothing, my lord, nothing.
quantity?
And moreover, section 50 is also not compliant.
So usually it is certified, the
Yes.
quantity.
Yes. And my lord,
It has to be.
section 50 also not compliant with, my lord. No, he is not police before the gazetted officer. He is to be charged in presence of the gazetted officer, my lord.
It was recovered from his body.
No,
No, then
four
50,
plastic bags.
then 50 only
will not.
applicable. 50 is only for the body.
Yes,
Body.
and then 51. 51.
From pocket, that will
Yes.
come.
Yeah, pocket will be, but packets, my lord. it
The
will not.
packets will be different. It will not come.
For lot-
The notice, my lord, there, more interesting fact is this, my lord, the family members not get any information where his son, when he was arrested, my lord. After a long time, they come to learn that he was arrested.
These
my lord.
are these things should have contemporaneous materials in the CD
CD.
that he was, because here on the face of it I do not find
Yes,
any other signature other than the accused and the police officer. But if it has been informed, it has to have a correlation with the CD.
For lordship convenience, well, if it is taken tomorrow, well, I can see all the.
No, science. My lordship already gone through it.
No, but case diary parts. And with regard to 37, one thing has always bothered my mind, that after framing of charge, how do you say is prima facie not guilty? That is,
It is-
the prima
it is
facie
correct.
materials, that's
Now,
why charge has been framed.
I will face the trial. No
So either the trial court is right or bail court is right.
Well, I will
So-
face the trial, no problem.
No, that's not an issue.
I will face the trial, but actually this, my lord, how can such frame, my lord?
No, 37 determination.
And how can such frame without determining the weight of the actual weight of the articles, my lord? It is nowhere I found that the 4 packets plastic
They have
has
like
been
commercial
detected.
quantity only. They have bought by commercial quantity only. The
No,
thing
no,
is
cannot.
that
If
The
some-
quantity, no, charge
Yes, yes.
frame, the thing is that it is very crucial for the question of bail.
Yes.
But
Suppose, my lord, 4 packets detected, then it will come down under 20 kg, my
we do
lord.
not
Then
know-
it will come
No, we do-
under below
we do not know.
commercial.
Likely, but we do not know what is the weight of the packets, right? That is the,
That
that is the problem.
That is the irregularity
problem.
conducted, my lord.
That
That
is
is
the
the
problem.
irregularities, my lord.
Anyway,
So, my lord, anyway, my lord, by considering the length of detention, I will cooperate, my lord. I will fully cooperate with. And since no notice under section 488 has been given to the family members and even his friend after arrest, my lord, the petitioner is entitled to get bail as per Bihan Kumar.
I think you should take some time in this, and see it properly. I don't know whether the materials are sufficient to make this, because this is, we do not know what is whether a section of C will come or not.
Yes.
Secondly, the other aspect, what are the other materials against him with regard to C.
In my learned from
Hmm.
entitlement.
Definitely we can consider, then since if C comes, then what are the materials we have to see? What are the C? You take some time, take some time.
Then, what is the
So
weight?
don't fix it tomorrow, you take some time,
Monday, my lord. It is
Monday or Tuesday,
Yes,
it's better to have a
Tuesday.
considered decision rather than hurriedly make a
Yes,
mistake.
my lord. I have no problem. Then only problem, my lord, that
37 determination has to be done very
Yes,
carefully,
yes.
because once the determination is made by, suppose at the High Court level, only apex court can overturn.
my lord. The only problem is, my lord, let them clarify the weight of the.
They clarify
Yeah,
the sampling, the sampling document is the only hope, because it is there or not there.
I'll satisfy from.
Usually it is there. Usually it is there. The magistrates are trained nowadays. They know how to
Yes.
belong the packets to measure it. Anyway, I think please. Third one, so Ahmed and prosecutor. The scanned diary is available. And relevant portions perused. However, the learned additional public prosecutor seeks some time to address some aspects of the matter, especially with regard to the quantity and the applicability of penal provision pertaining to commercial quantity. Full stop. I'll list the matter on Monday or Tuesday.
Monday.
Tuesday.
Tuesday,
No, Monday.
Monday.
1/12.
Yes.
Suppose, my lord, plastic, they are not separated weight. How can my friend?
Then it will be
That is
tough
benefit.
call actually.
Yes, this is a fault, my lord.
If it is very borderline, you can give
Yes.
the beneficial
Yes,
interpretation.
my lord. It is the better, even now, it like borderline, my lord. Hello, bless, my lord.
No, let's go for the mentions.
18.
No, mentions.
Really good.
No, you can mention in a relaxed manner. I'll not rise. Complete everything and then.
18 number item 10.
18, okay. That way also we can make.
May my lord, Pokso matter, my lord, this is second petition, my lord. Order your lordship rejected the
Yes.
prayer, my lord.
No issues.
Because the victim was not examined. This time, my lord, victim and informant has been examined, my lord.
Let it come up on 5th.
Fifth, my lord.
5th.
My lord,
When do you want it? Sir? When?
my lord, whether notice was served or not.
Oh, notice.
That is also not clear.
My
Not
lord,
clear.
let them take the instruction, my lord.
Yes.
I will also take the.
Instructions regarding service may be taken. Service upon informant may be taken. List the matter
On Monday, my lord.
on. No, don't take it.
He is behind the bar for my lord 6 months. For a long time, he is behind the bar.
Lots of matters on one day. It will not reach, since they will be left over. So many matters. Listing is easy, but it don't reach. The big problem. I understand your difficulties also, but
This year has been, my lord,
112.
Ma-
112. So,
Ablash,
yes, next.
Item 19.
Yes, 19.
Possibility is available, possibility is regard to offense, instead of 60 days, Lordship. And Lordship, all the offenses are available, Lordship, I will submit. Can be tomorrow, Lordship, CD is available, not Lordship, any special other clock to act, Lordship.
Okay.
Yes. So,
Next.
Lordship, item number 6.
Oh, admission. You could not touch admission. Yes.
So every time this matter is coming and left over. So this time I would request the honorable court. to kindly fix it on-
Let's have some automatic mechanism of leftover matters. It can be done by technology. We'll work together and do it. But for the moment, when should I? We can fix it on a hearing day. That's all. What can you do? Hearing day, there will be fewer matters.
Can it be on 16th?
Six.
Six. No, my lord, can it be after 8, my lord?
No, Lordship, because it
No,
is
every
Lordship,
time they are
there is
taking this
interim
kind
order,
of-
Lordship.
But
there
I
has
am
been
not
Lordship.
taking time, my lord.
Every
No,
time,
not taking
last
time.
time
No, no.
also, they have taken the.
Nine,
stand.
12.
Nine.
Fine.
Hearing day, it's Tuesday.
My lord, 9 is Wednesday, my lord.
Wednesday. No, let it be on 8th then. 8.
Eight.
But
Nine.
can it be on 10th, my lord?
No, just a minute.
8 is Tuesday, Lordship.
No, 9th is Tuesday.
9th is
Tuesday.
19th.
I remember. It's Tuesday.
Then can it be on 11th, my lord? 11.
No, sir, every time
11.
they are taking.
I have only 1 day accommodation, my lord. 11, my lord.
Okay, 11.
No, 9th. Please listen to me, Lordship. 9th, I have a matter in this court. I am coming from Tinsukia. So it will be
My lord.
convenient if it is fixed on 9th.
My lord, I have some difficulty on 9.
So,
Lordship, senior
Yeah,
comes the
every time-
case, so they
what
will
to
leave
do?
the case, Lordship. So he will be able.
11th, my
So
lord.
kindly accommodate on 9th. So that
you decide and tell me.
Please, your
I am coming from distant place.
Okay, 9.
9th.
May I please your
No
lordship?
problem.
Lordship, with due respect, my lordship, item number 61 and 62, my lordship.
Hmm.
It came up on 25th and because of urgency, it was fixed today. My lordship, there is urgent. Can it be fixed tomorrow? 61 and 62 last came up 25th, my lordship.
We can fix it.
Tomorrow, my lordship, can we
fix it.
make it try, my lordship?
We can fix it.
61 and
Fixing is
62.
not a problem. We can fix it.
61
But
and
I don't know.
62.
Today I could not even finish the bail list. We have to go faster, shorter. Okay, tomorrow. 61, 62. Tomorrow.
Master bless, my lordship.
It will come in supply list. It will come in the supply list. Yes.
Yes, my lordship.
Lordship, item 59 of the supplementary list, Lordship. It is ready for disposal. Only ground is the violation of Lordship 47, 48, Lordship. Can it be taken up tomorrow, Lordship? PCI is also there.
Lots of matters. Lots of matters tomorrow. Some other court maybe.
Maybe Lordship on that Monday.
Monday.
Lordship. Lordship, in item 6, Lordship, CD is there, that can be retained, Lordship. Maybe retained, Lordship. Item 6.
6.
CD is there.
Oh.
That may be retained, Lordship.
Item 6 or CD may be retained.
Lordship. Oblate.
Lordship, item 34 relates to a bail order modification. Already a similarly situated co-petitioners have
Yes.
taken bail
Okay.
modification.
Tomorrow?
Tomorrow. Wait,
34.
Item 46, 47 and 48.
Yes.
My lord, they are getting left out. My lord, may I pray that it may be taken up on 11th of December. The other councils I have also talked to them, my lord. 11th is convenient for
Mhm.
everybody.
11th at
11th
2.
of December, top of the list, my lord. 2 also sometimes a lot of congestion there at 2 o'clock, my lord. Because your lordship has partly heard it, though it's not as part heard.
Hmm.
That is the only issue, my lord. We will not be going into the merit of the case.
It is submitted for legal. We submitted Mr. S. Nawaz Learned Counsel that this matter has been has come in the list on multiple occasions, but has not reached due to paucity of time, and submits that the matter can perhaps be disposed of on a law point, and therefore prays for listing the matter. Listing the matter on the next date, at the top of the list. I think I'll be more comfortable fixing it at 2. But we'll do it. List on 2, at 2 p.m. and we'll take it that day. It's
11th of December, my lord.
11th of December.
Yeah.
Okay.
I'm deep.
All of you are such bright, intelligent minds, work together, and we should find a system. Technology is available, automatic, those which are not to reach, they'll automatically come, I don't have to worry. Nobody has to worry. And it will come automatically, which are the last matter today will be the first matter and that matter in that list, the second list after motion, something like that.
Deeply.
46, 47, 48.
May I please, Lordship, item number 60. From supplementary list. More than 4 months. And he is a physical disabled person.
When do you want it?
Tomorrow or Monday, Lordship?
Tomorrow, I do
Or
not know
Monday.
how many, but lots of matters, he says. Tomorrow, Monday. Mm.
May I please,
Take some dates on the 4th, 5th also.
May I please, Your Lordship? May I please, Your Lordship? Item number 64, Your Lordship, the bail hearing list, Your Lordship.
Mm.
Yesterday also I mentioned it for today's list. My Lord.
It came but did not reach.
Yes, Lordship. Can it be on tomorrow, Your Lordship? The petitioner is unnecessarily, Your Lordship, languishing in judicial custody. Moreover, the CD has been received, Your Lordship. At least on tomorrow's list, Your Lordship.
May I please, your Lordship? Item number 7, Lordship. So the matter taken after 11th December, Lordship.
7.
Yes, Lordship.
Admission matter.
11th of December.
11, take it on another day because I'm just 11th is. Don't know how many matters. Okay.
11th?
Obvious Lordship. Thank you, Your Lordship. Lordship,
Yes.
Item number 32, a date may be fixed, Lordship.
32.
Yes, Lordship.
Criminal appeal. It's come for orders, no? Criminals. You want a date, suggested date?
Any date, Lordship.
Any date? He's in custody? He's in custody. Hmm. Eleven, 12.
Lordship, on earlier occasion, other side also took time for filing a objection, Lordship. So, Lordship, in the meantime, they will file.
Yes. The informants, eh? Informants?
No, state.
State. Oh,
32.
it must be in the IA.
Yes,
IA must be in the IA. The objection, if any, by the prosecution shall be filed in the meantime.
May it please, Your Lordship. Item number 33, can be taken on 5th of December, Lordship permits.
Okay, let's fix it.
5th of December, ma'am.
Let's fix it.
33.
32.
May I please, Your
Much obliged.
Lordship, item number 5.
Yes.
Lordship, 1st of December, can.
1st of December, this is
Monday.
24. Let's fix it a little later. 5th, at least 5th, if not on, or 8th. 5th or 8th. 5th or 8th.
Can be continued.
Yes, interim will continue. Interim will continue. It's not your
May it
fault.
please, Your Lordship.
It's 8th.
May it please, Your
8.
Lordship. Item number 38.
No, it's already, it's not, one was, also you had mentioned. Paucity of time. Paucity of time. Paucity of time. You had mentioned some date, na, when you want it. Let it be prosecution. Let it be in January. This one, this series matter. Oh, you're not here, no? Let it be in January because it will be impracticable to fix it. Let it be on 8/1.
8/1.
8/1. Thursday. But one day hearing will not be complete in this. Okay.
Hare Krishna, Hare Krishna.